আপনি করে দিবেন সেটা কি
আজকে আছে না
এটা আপনি May I seek Lordship's kind leave to mention one matter, my lord, which was permitted by your Lordship to be listed as a upgraded motion.
mentioning is not being taken up now, sir. You're aware.
No, it was directed by your Lordship to appear as upgraded motion.
Maybe
It
please
appeared.
go to the first line of my list. I will not take up mentionings now.
It is required to be upgraded. It was appearing as upgraded. State
Please
government
wait for
did not
some-
appear.
Please wait for some time. Non-prosecution, yes.
Kindly,
See the first page of my list. I cannot discriminate, isn't it? Yes, call the days list, please.
Item 1. Item 1, I beg to appear for the petitioner.
What is the
Matter
correction required?
My lord, I fail to understand what my your
नहीं file है. It says come back from the department.
that court officer,
part,
my lord.
yes.
In that even, my lord, we will ask the client to make another, because
There
that time it
some
was
instruction which was
my lord,
not of
that
record.
point of time it was handed over, my lord. Probably it's not there for some reasons or other.
Will you give me a copy?
I will give you a copy. I will ask the
Not
client.
this week.
Not
Not this week. Next Monday.
My lord, already been directed to file an application for extension of interim order.
Have you served the other side?
Other side already served. Now I have already filed the petition. The order which has been passed by your lordship, that was in force in 15/12/2023. Thereafter, my lord, kindly see that due to honorable on part of the advocate, he was not appear, and therefore it is not possible to take proper steps.
Till 15 December it was granted. So have you filed an application?
Yes, I have already filed an application.
দিদি একটা application আছে CAN 1 of 2024. Have you served copy of the application?
My lord,
Where is your affidavit of service?
affidavit of service.
Where is your affidavit of service?
No.
Have you served copy of the
I
application?
already served the copy of the appearing on behalf of the state respondent.
Copy of the application CAN 1 of 2024.
Yes, my lord.
Where is the affidavit of service?
Affidavit of service I have not filed, but I have already served the copy.
To file an
Copy
affidavit of
covering
service.
letter.
You're asking for an interim order which doesn't exist at all. You have filed an application, CAN 1. You have to serve the application upon the other side
Already
and
served.
file an affidavit of service.
Not yet filed.
How do I know that you have served?
There is a copy. There is a record on this section, the left side of the lecture.
This is a mentioning slip which you have served. You have to serve the application.
Already served the application. Okay, I'm just now filing the application service today. I'll file.
Please file.
Okay.
You can 1 of 2024. The applicant petitioner is directed to serve copy of the application upon the respondents and file affidavit of service on the agenda date. Paragraph, let the matter appear under the same heading on 9th April. Please file affidavit of service on the
By
agenda.
today. My lord, I had your respondent number in item number 2.
Item number 2, you're appearing.
Affidavit of service file করতে হবে।
Prabhash, কেটে
Affidavit
দিন।
of service.
Yes, he is asking for extension of the interim order. Let it be extended for a limited period.
উনি বললেন affidavit of service file
Can you ওটা কেটে দিন? Heard learned counsels for the parties. Paragraph, it appears that the order passed on 18th October 2023, this court granted an interim order in favor of the petitioner which expired on 15th December 2023. Stop.
My lord, it was expired on 15 December 2023.
That's
My
not
lord, friend
called-
should have approached before the court earlier, my lord.
That
It-
is
it
not
has-
a
it has
call for
expired long
second
before, my lord.
application.
Yes, ma'am.
Generally, applications are not called for.
Yes,
Since it expired earlier, I called for an application.
yes, ma'am.
Yep. Have you filed affidavit in opposition?
Yes, 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 ma'am.
The reply is awaited, I think.
Yes, yes.
The reply is not filed as yet. Paragraph, affidavit in reply is yet to be filed. Paragraph. In view of the fact that this court granted interim relief to the petitioner upon consideration of the material on record, the interim order granted earlier be extended till 30th April 2024 or until further orders, whichever is earlier, can one disposed of. WPA তে order করুন. Let the matter appear under the heading Group 1 hearing on 17th April.
Grateful.
Please serve your affidavit in reply in the meantime.
My lord, in this matter, I am led by Mr. Asim Kumar Kamble. He's in court number, my lord, 2381. April.
Item number 3.
Appearing on behalf of the petitioner respondent. He is engaged in report number 654. I'm praying for not today.
Comply.
My lord, that is a review and contempt, my lord. Contempt and file review also.
So let there be a date. On prayer of the applicant petitioner, the matter is adjourned.
My lord, only I am praying, my lord, your lordship was pleased to direct us to come with original, my lord. We come original at every time, my lord. Today, my lord, your lordship.
You need some time, some more time.
No. My lord, I am today also, my lord, come with all the document.
Oh,
My lord, no, all the document is not necessary, my lord. Your lordship will hear, ask, my lord, and see everything. In spite of that, my lord, I personally, my lord, showed all the documents to Mr. Amit
Today,
Kumar.
Mr. Pan is not there. Please come back on the next date. Let me see.
My lord, I must not come with the original, my lord. Two persons came, my lord, one officer and one, my lord, attendant. My lord, it's a very difficult job. Your lordship will see how many times is there.
Well, let us see. Let him come
Yes,
back. Let
ma'am.
us see. 15th April.
State Guru.
Client for the petition. And your lordship, last occasion, 10 times has given time to take an
No, I
abstract.
did not take time. But we have got the report only by passes over for at let it taken at 12 p.m. I have got the instruction, written instructions. Written instruction is that we will no, there is no scope for compensation. The other point which has been submitted by which has been proposed by your lordship, we have taken that and we will
Demolish the road.
no, we will restore the land as your lordship desired. So, my lord, can be taken up at 12. The Birbhum Jila Parishad is coming
12 o'clock.
at 12.
দিদি 12টার সময় রাখুন।
Your Lordship, item number 6, I am for the petitioner. I am led by Mr. Bikram Banerjee, Your Lordship. He is engaged in a matter in courtroom number 13, Your Lordship. Kindly grant me a short passover or
Passover is not possible in this court, you are aware by now.
make it not today, kindly make it not.
On prayer of the petitioner, the matter is adjourned. You are appealing for the respondents?
Respondent, private respondent, 11 and 12. Some of the statement.
Let it be adjourned. The petitioner is not there. On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 16th April.
That's why I'm grateful. This is.
On the last occasion, Lordship direct my learned friend to produce the inquiry
Have
report.
you gone through the instructions?
Question is, my lord, Lordship can listen. This is the scheme. That scheme, my lord, was giving us that the person losing land, he will get some land for homestead land. He will get that 3 decimals or odd lands. He will get. Now, our claim is that we have father died in 2087, 1987. Acquisition was in 1997. We are all separately living, separate land. Land is only one plot, but a big land. We have got the separate homestead. They said no. There is only one building. Now, Lordship knows, under Section 8, there must be an inquiry and demarcation before acquisition. We pray for the report. If it is proved that is only one building, then I have got no case. They have already allotted only 6 decimals of land.
If you are occupying separate buildings, please
Yes.
show me the documents.
Documents means, that's why it is their inquiry report they will show what they have said. It is not my duty to the report. Kindly see the order. Kindly have a look. This cannot be a one-way traffic. They said without any documents that I have got only page 35. Like kindly see. Kindly have a look.
The land was in the name of your predecessor.
Yes.
After his demise, it has not been partitioned.
Yes,
joint
they have already recorded in their favor. That's why I pray for. They separately recorded. I have annexed the record of rights. Kindly have a look to page 35. Kindly have a look to their order. Petitioner's land, one double-story dwelling house. This is their, according to them. Along with baranda, cow shed, husking machines, water tank, Paka platform over the plot number 293 was acquired. You kindly see, according to them. At Mouja such and such, they reside jointly using the dwelling house according to the total structure. Compensation along with compensation was delivered divided equally 1/7 of 1,000 and separate awards were declared as per land acquisition, and petitioner claimed that they are separately used to possess more than 6.06 acres of land of the said land. This is their apartment, and on the basis of that, they have passed this order. No matter what I am praying, that on the basis of which report, certainly they inquire and report.
The
without any,
the
can't you
acquisition
see?
document
RTI,
say-
we have given the RTI, can't you see? Page 36. What they have said, madam, this cannot be. Madam, justice for both the parties, not for them and not for my also. So it cannot be said. Since I have said, then it is the only,
If you have separate residential units,
yes.
you have separate building plans for the residential
No,
units.
no, sir,
You
my
have
lord,
separate
no, my lord, no
documents for
building.
residential
There is
units.
only some, there are 7, no building plan in 1987, 86. Is there any plan? Building plan?
Acquisition is in 97, you said.
No, 1986, 87,
96, 97.
96, 97.
In 96, 97, there was very much
No,
building plan.
no, Lord, you can see. If that is so, if in the remote village,
If you have different buildings, you have to substantiate
madam,
that you have different
may I said only one thing. If they said only 2-story building and Pakistan, let them produce the assessment roll. That Lord, you can see, this cannot be in this fashion. This cannot be. They never supply any report. Kindly see.
The acquisition.
What they have
once-
said, no, not admission. We never admitted that this is our.
You are not listening to me. You are only
If
going on
they,
saying.
only one way traffic, they said that this is the only structure, so you will get more, cannot get. Lord, you can see. That's why we apply for this report. We have applied. And what is the reply I will show? Can you see the reply of the they said there is no report in the file. I'm showing my that's why we file an appeal. If Lordship will not, I think Lordship will not take into consideration of any other things, because I've gone at this stage, after such a long gap, there is nothing less can see their report. They have said. Can you see?
What is this?
This is we pray for the inquiry report.
What inquiry report?
That what they are saying on the basis of the report they have allotted 6 decimals. This is the only there is the same thing. No report in the file. 1919.
Where have they referred to a report in the order? There is no reference to a report.
Let them produce that report.
Which report? Where is the reference to a report?
Under section 8, also can you see demarcation and report.
They have, if
This
they
is
have taken the entire land, no question of demarcation.
no question of entire land. This part which they are saying, this part they produce. This part I
You
know.
cannot claim that you have separate residential units.
Cannot
If you
claim.
no,
I-
burden of proof
This
is
is
on the
very
petitioner.
unfortunate, Mala. This is
Burden of proof is on the petitioner. Please show me one single document.
they have said they have to prove. Let them say what they have said.
It is your claim. It is your
I've
petition.
got nothing to say. If you also think it is one way traffic, I shall get justice. That is, I've got nothing to say. I've got nothing. Since the officer says that, this is sacrosanct. That is the only order. I've got nothing. So then Lordship, whatever Lordship like Lordship do it.
Yes, Mr. Dev.
My lord, it is very clear from our report, without filing any exception or anything else, my lord. In our report, my lord, we are very categorically stated, according to the provision, my lord, of Panchayat Act, my lord, there is if there is a dwelling house, he must produce, and he is a petitioner, my lord. Prima facie, he must prove that he has any case. Practically, he has not any case. He is now stating, submitting before your lordship.
Let them
I
produce
don't-
the inquiry report.
I don't
Everything will
understand that.
finish. I will
I
have
have
nothing to
already-
say.
I have already,
Produce that report.
I don't shouting.
Will you please maintain the decorum of the court?
I'm
at
sorry.
least?
I'm sorry.
My lord, we have already filed one report that is in instruction, brief history in connection with that, my lord. And we have stated all the facts and figure of the same, my lord. And according to the, my lord, provision, my lord, petitioner must prove his case. I am not proving his case. But my learned friend wanted to no, my lord, that he is not the petitioner. I am the petitioner. State is the petitioner. Here, for that is, my lord, if your lordship will see order of the Honorable High Court in MP number Ato respondent state authorities. Now the reason order of Rehabilitation Advisory Committee. The matter was placed at the direction of the Honorable High Court in W in the matter of Amalindu Das and other state versus Ato Rehabilitation Advisory Committee Holdia on Ato 17. And the reason order was passed by the Rehabilitation Advisory Committee as follows. The petitioner claimed constructing a separate dwelling house over plot number 293 and residing a separate dwelling house cannot be granted and accepted. It is crystal clear from the office record that only single dwelling house over the land, over the said plot was acquired and the structure compensation was paid. My lord, 1/7, not the
All legal
years. That is the according to share, considering Ato share of the single structure. Separate award serial number Ato does not indicate that there was separate dwelling house for each award. Number 1 reflects the compensation of each. The award serial number of all clearly proves the total awarded amount of structure were equally divided among them. If there are, my lord, 7 structure, my lord, then we must calculate 7 structures value and each of them will get, my lord, according to the structure value, and every structure value is not the same. My lord, it is very clear that 1/7 of the structure value. That means, my lord, only one dwelling house and other things, my lord. But, my lord, when he has got a chance, my lord, to submit before there, he must produce all the photos and other things that we have the 7 photos, that 7 dwelling house, that we may not want, we never restrain him from, my lord, producing those records. No records was produced before us, my lord. We are getting what we see, my lord. According to us, my lord, we have done this. If he wants to contradict that, my lord, he must produce the photos, 7 photos that our 7 dwelling house is there, and we must get the, my lord, 7 dwelling house must not be the same proportionate value. Every dwelling house has some its own value. So, my lord, it is very clear from them, my lord. Petitioner failed to produce nothing. And, my lord, he wanted to show, my lord, and wanted to submit before your lordship nothing, which is not a petitioner should not say before the honorable court, my lord. And now, my lord, hence it is unanimously decided to pass a reason order that 0.6 acres of rehabilitation plot for acquisition of homestead land with Ato, bike number Ato, Mouja Ato, is recommended jointly in favor of Amalindu Das, Ujjwal Das, Atinto Das, and others. My lord. The petitioner filed the writ petition before the Honorable High Court, disassociated with the agreed by the reason order of the Ato and quashed the order. He has come, my lord, with that order. He has not come with the photographs and other things, my lord, that we have 7, now we have 7 dwelling house, and that is the 7 dwelling house photos. My lord, everything. Petitioner has not prima facie, my lord, proved this case. So petition should be rejected with cost, my lord.
Lordship, kindly come to pay. হয়ে গেছে?
আমার হয়ে গেছে,
Page 19 of my petition.
1919.
19 of my petition. Whether it is my documents or their documents. Kindly see how many Vastus are there. Area is also there.
Vastu, does Vastu mean house, residential house, or the classification of the land?
They have kindly see. Vastu, what is the
Rehabilitation in respect of the dwelling house, not in respect of the land.
There is no dispute with regard to the land. He is only claiming rehabilitation, separate rehabilitations.
Now he is showing the land portion.
Vastu is land. There are 43 decimals of land total. I am not claiming Vastu in all the Indian land. Kindly see.
Vastu
My lord.
doesn't mean residential building, sir. You are an experienced counsel, you are aware. Vastu is a classification of land. Does Vastu mean residential building?
My lord, Nidhi,
Please.
I don't know what prevented them to produce the report. I don't know why they are so much.
What report
Yes.
are you talking about?
report of the exact what they are saying
Where,
in the order.
is anywhere it is stated that there is a report in any of the documents? I do not find so.
They said,
Yeah.
on the basis of the report in, kindly see the order. But why am the kindly see,
Where do they say that on
My
the
lord,
basis of
kindly see.
report?
my lord, kindly see. Construction, several dwellings over at such and such. Dwelling house cannot be granted except report. Is the rule. My lord, kindly see. From the office record,
At page,
page my lord 35,
paragraph?
paragraph, reason order. Reason order.
Yes.
From the office record.
Office record is not a report. It is the acquisition.
Let them produce that. Let them produce. I have got no case.
What will they produce?
Office record.
It is record, they have recorded in the, it is a reasoned order. I think it will be better if I release the matter because I find the expression of learned counsel is not very happy. I'll release it for a better court to handle the matter. Yes, sir.
As your lordship please, I will not say anything more.
No, because you're expressing your anguish before this
I
court.
don't want to say anything. But this is the position. I canvass all these things. As your lordship please, your lordship will do. I have to do nothing.
He feels he'll not get justice here. I'll release it.
Yes, my lord, release me.
It appears from the submission made on behalf, made by learned counsel for the petitioners that he is apprehensive that his matter will not be dealt with in a proper manner by this court. Stop. Learned counsel submits.
My lord, I'm requesting, don't say this. Please, I'm requesting, I'm busy.
That is
My lord, your
exactly
lordship
what
pass
I'm
the order.
Lordship
My lord,
pass
your
the order.
lordship pass the order.
Lordship pass the order. I don't want to say
I will
anything.
record your
Sorry, I'm
sentences, then
sorry,
I have
I'm
nothing
sorry.
to say if the court
I'm
doesn't-
sorry.
That means you'll not get justice before the
I'm
court.
sorry.
My lord, then your lordship pass the order.
As your lordship thinks, please, lordship pass the order.
Get it.
I will not.
Heard learned counsels
I'm
for
the last
counsel.
person to blame the court.
You are actually
But
doing
I'm
that, sir.
sorry. I'm sorry.
The petitioners have claimed rehabilitation plot to the extent of 0.06 acres for each of the petitioners on the ground that after demise of their predecessor in interest, who was the original owner of the property, each of the petitioners were in possession of separate residential units which were acquired by the respondents. The petitioners have placed reliance on the letter issued by the Deputy Secretary to the Government of West Bengal to the Collector, Midnapur on 20th April 1993, which demonstrates that person losing more than 0.03 acres will be allotted a full plot measuring 0.06 acres. Admittedly, the petitioners have been allotted a full plot of 0.06 acres jointly. Paragraph. Pursuant to an order passed by a coordinate bench of this court in WP 6517 within bracket W of 2009 on 23rd August 2016, allowing the petitioners to file appropriate representations disclosing all documents, including the records available with them relating to the acquisition proceedings in respect of the plot in question before the chairman, Rehabilitation Advisory Committee, Haldia, and directing the chairman to dispose of the same upon granting opportunity of hearing to the petitioners within a stipulated time frame. The petitioners submitted a representation before the concerned authority, which was considered and turned down by the authority by the order impugned dated 5th April 2017. The order impugned states that the petitioners S.apostrophe land with one double-storied dwelling house was acquired Vide LA case number 12/96-97, 12/96-97. And structure compensation paid to them in 1/7 share each. The order further indicates that the separate award serial number does not show that there was any separate dwelling house of each of the petitioners. Stop. The total awarded amount of structure was equally divided among the petitioners. The petitioners are entitled to get 0.06 acres of rehabilitation plot jointly. Paragraph. The order impugned is a reasoned and speaking order which deliberates upon the submission made on behalf of the petitioners. So there is in fact the petitioners have not been able to produce any document to suggest that each of them were in possession of separate residential units which were acquired by the respondents. Since the petitioners jointly owned the single double-storied dwelling house in the plot, they are entitled to rehabilitation plot of 0.06 acres as decided by the authority. Stop. There is no illegality or irregularity in the order impugned, which calls for intervention by this court. Paragraph, the writ petition being devoid of any merit is liable to be dismissed. Paragraph, accordingly, WPA such and such is dismissed. And there shall have been no address costs since no affidavit has been certified.
My lord, I telling my apology before my lord. If my lord heard it, I don't think that.
Before a court,
Well, I'm
you should be
sorry.
very careful in choosing your.
My lord, difficulty is this. Sometimes it happens. Because
Never.
Lordship knows, but this is a course of. Don't take it otherwise. Get through.
And at least for the state response.
Time for the petitioner, my lord. My lord, 0.45 acres of land was acquired
Yes.
for my lord, a construction of water project my lord, by the PhD department. My lord, I got my lord, I got my lord compensation for that. And whatever grievances I have filed my lord application under section 18 my lord, that is pending. What happened my lord thereafter? My lord, the authorities forcibly taken my another portion of land, that is
They have
40
utilized it without acquiring.
Yeah.
The last order, my lord.
Yes, I've seen that. You were supposed to take
Yes, yes, yes,
instructions.
ma'am.
Yes.
I got the instruction, my lord.
What is it?
Government has taken initiative to compensate the petitioner. Process is going on, my lord.
How are you going to compensate the petitioner?
My lord, this is my instruction.
Because the petitioner is asking for compensation.
Yeah,
right?
I want the value of the land, whatever the land there.
Unutilized 84 meters and 4.3 meters of.
I want the value, my lord, according to present.
Yes,
market
84
price.
and 4.3. Yes.
The process is going on, my lord, but my instruction is it will take time, some time, my lord, but we will get this compensation, my lord.
Time, my lord, that should be specified.
This is the process for direct purchase. Direct purchase. What are you planning to do?
They have stated that, my lord. This is not only for the petitioner, it is a composite chart, my lord. Not only for the petitioner, but so many other beneficiaries. Kindly look into the last para of the instruction, my lord.
Yes.
That about the process for compensation for the cost of land has already been initiated and subsequent formalities are required to be followed for effecting payment of the same.
So it is by way of direct purchase.
Yes.
Yes, my lord.
So I'll grant you 3 months time, pay the compensation within the set period.
I hope, my lord, it will, my lord, I hope so, my lord.
Yes.
We must have
You are
enough time.
representing the state, you should
Yes,
say
yes.
by a,
But specific time, I can't say, my lord.
you have to say.
Yes.
Well, you don't need to say, the court will give you specific time.
Yes, yes.
3 months time.
Let it be 3
Their
months.
instruction is, my
Yes,
lord,
yes.
it will take some time, my lord, but
That
how
sometime
much-
cannot be indefinite, isn't it?
Yes, my lord.
It has to be fixed.
Negative jacket.
Inspection.
It is admitted by the respondents that they have utilized 84 meters and 4.300 meters of the petitioner's land, plural, for construction of a road without acquiring the same by due process of law. It is also not in dispute that 0.45 acres of land of the petitioners were acquired and compensation paid for the same.
Yes.
There is no dispute.
Oh.
একদম শুরুতে করুন, written instructions submitted on behalf of the respondents is taken on record. Paragraph. Placing reliance on the written instructions submitted by the executive engineer, North 24 Parganas.
Public engineering.
Yes.
Public health engineering.
That is, Public Health Engineering Department, Learned Counsel for the respondents submits that the respondents shall compensate the petitioners for utilization of their land and direct purchase of the land is under consideration of the authority. Paragraph. Since admittedly the land of the petitioners has been utilized by the respondents without acquisition, since admittedly bolam to, comma, the petitioners are entitled to compensation in lieu thereof from the authority. Stop. In view of the above, sentence paragraph. In view of the above, the writ petition is disposed of, directing the who should pay? The district magistrate. The district magistrate. He is the purchase committee.
Payment will be made
Chairman,
by
I think.
PhD department, PSC department.
The district magistrate is the chairman of the purchase committee.
Yes, yes, that's true.
The district magistrate and collector, North 24 Parganas, being the third respondent herein, is directed to
Respondent number 3.
Yes.
three. Yes. The third, oh, that is one. So to initiate,
No, my process is going on. Initiation has already been taken.
process is going on. To
Complete the process.
pay compensation, to conclude the
Yes.
process of direct purchase, which according to learned counsel for the respondents, has been initiated, and disburse compensation in favor of the petitioners in respect of the plot in question, according to the present market rate of the plot, within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, in accordance with law.
In respect of the said plot of land, the measuring 84 meters and
I've
4.3.
recorded that first, yes. The decision taken by the authority shall be communicated to the petitioners within a week thereof, disposed of which 3 months and 1 week. Next. Item 9.
I'm for the state respondent.
Petitioner,
Devashish Bandyopadhyay was appearing. We took the point and settlement of Jolkar, land reforms act will come in. And they
Oh.
took the point that no, it's under land reforms manual, so it shall not.
where is he?
What's here?
He wanted to use an exception to your report.
Exception to mine. Possibly, because no, we have settled in favor of another person. Possibly, it might be so that they have lost interest because of that. Huge amounts were due. He wanted consideration, remission of that amount. 76 lakhs is due from him. He wanted remission of that amount and fresh consideration and lease.
Let there be a date because he's not there. None appears for the petitioners. No accommodation is sought. Paragraph. Let the matter appear under the same heading on 26th April.
26.
26th. Item 10.
My lord, before I'm for the petitioner, before your lordship takes up the matter, my lord, I should be candid before your lordship. My lord, I need some more time to get prepared because new things have come up. Certain provisions of law and the rules of the Town and Country Planning Act. My lord, this week maybe I'm praying for accommodation. Exception we have prepared, but my lord, I need to go through it. I am being candid before your lordship. My lord, some preparation. is required.
I do not oppose it.
It is required for, on my part, my lord, because without preparation, my lord, I don't want to appear before lordship because it involves certain complex issues of the statutory interpretation, my lord. I need some time for preparation.
My lord, I am appearing on
this
behalf of Bardhaman Development.
Only this week, my lord.
Learned counsel
Well,
for
may I hand over the,
petitioners.
in that case, my lord, if so requires, I would prepare a second exception to that. I'm not handing over it today.
Comprehensive exception.
Yes,
will
yes,
come back.
yes.
Since you have not filed as yet.
Yes.
Let him file today.
No, my lord.
you
I-
have to add.
Yeah, possibly I would add some.
Let him prepare comprehensive.
Already served, my lord.
Learned counsel for the
I'll not
petitioners
place it.
seeks. Learned counsel for the petitioner seeks further extension of time to use the exception as sought paragraph. Let the matter appear under the same heading on 16th April.
My lord, grateful to know.
Please serve an advance.
Yes, my lord.
My lord is fixing on
16th April.
16th April.
16th April. 16 April. But
Tuesday.
Tuesday.
Next. Huh?
Grateful to lord.
16th April. No. Order for it. Huh?
In case my learned friend had submitted the copies to my learned senior friends, in that case, we'll take it back and give the fresh application.
I don't think he has because
after affidavit, it cannot be
After
taken.
affidavit, my lord, here.
I have not placed it. I have not placed.
not
You
filed.
can file it today and say I am not present.
That I'll on the next occasion.
Not filed at all.
I have not filed it.
But it
It's
has
a
been,
question of taking back.
Yes.
but it has been affirmed, my lord.
Your copy doesn't have an affidavit, I'm sure.
Affirmed, my lord.
What I am submitting. The moment it is affirmed and served, you can say I am withdrawing that affidavit.
On the next
He
occasion.
can add another supplementary
Yes.
back
what I'm
and
saying.
come back.
On the next occasion, I'll do. Great.
You cannot file praise.
Item 11.
For the state.
My lord, praying for some time, 1 week adjournment because advocate on record is ill and he could not come.
You are not appearing on any of the dates, madam. The petitioner is not interested at all.
The matter pertains to the Land Reforms Act, my lord, West Bengal Land Reforms Act. The date for, my lord,
So I'll release the matter.
can you see the prayer, my lord?
My lord, is there a liberty to mention?
I'll dispose of the matter here and now. This is under the Land Reforms Act. The matter pertains to the West Bengal Land Reforms. The matter pertains to the West Bengal Land Reforms Act 1955. I have to record the Land Reforms and Tenancy Tribunal Act. Land laws. You have the book.
The book, my lord, I don't have it. Section 2R, my lord, is a bar.
Land Reforms and Tenancy Tribunal. Land laws. Land reforms, no. Land Reforms and Tenancy Tribunal. Land laws. বইগুলো ছড়ানো আমার হাতের কাছে ওইটা দিন হ্যাঁ আবার কথা সেকেন্ড ভলিউম আমার চেম্বার আমি এডিট করে দেবো আমি এখন একটা কি লাগানো ছিল under the West Bengal Land Reforms and Tenancy Tribunal Act 1997, this court has no jurisdiction to entertain the present writ petition. Paragraph. The writ petition being WPS such and such is dismissed as not maintainable. Paragraph. However, the petitioner, however, liberty is granted to the petitioner to approach the appropriate forum for redressal of
Already one civil suit is pending, my lord, before the Lord Civil Court.
frequently dealt, because this cannot be dealt with by
They
this
also
court.
obtained an interim order of status quo, and they wanted to implement the order of status quo by way of filing this writ petition.
Regards. There shall however be no order as to costs, urgent certified website copy.
Yep, yep.
পাঠিয়ে দেবেন, আমি ওই ঢুকিয়ে দেবো জমা। Next.
I beg to appeal. Well, I have completed my submission more than 5-6 months ago.
Yes.
But I also completed, only I wanted to cite two
Decisions. Yes.
I shall not argue it.
No,
Well, this is on the point of suppression of material. I took that point. I relied on a order passed by the coordinate bench. But this is I could cite on the last. Well, this is reported in 2004 volume 7 SCC, page 166. But so, 2000 SCC 166. Well, paragraph 13, 14, 16, and 17.
13,
Here,
14,
my lord may kindly
13,
recall.
14, 16, 17. Yes.
My lord may kindly recall
This is suppression.
Yes.
Suppression.
that suppression is admitted and the petitioner wanted to justify that. Well, I am not repeating the facts, but only for that. So I am reading from paragraph 30. As a written, suppression of a material fact by a litigant disqualifies such litigant from obtaining evidence. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving. But the suppressed fact must be material one, in the sense that had it not been suppressed, it could have had an effect on the merits of the case. It must be a matter which was material for the consideration of the case. Whatever views the courts may have taken. Thus, when the liability to pay income tax was questioned by an applicant on the ground of her non-residence, the fact that she had purchased and was maintaining a house in the country was held to be a material. The suppression of which presented her to the relief claim. Again, when in earlier proceeding before this court, the appellant had undertaken that it would not carry on the manufacture of liquor at its distillery, and the proceedings before this court were concluded on that basis. A subsequent petition for renewal of the license to manufacture liquor at the same distillery before the High Court was held to have been initiated for oblique and ulterior purposes. And the interim order passed by the High Court in such subsequent application was set aside by this court. Similarly, a challenge to an order fixing the price was rejected because the petitioner had suppressed the fact that an agreement had been entered into between the parties, between the petitioner and the government relating to the fixation of price, and that the impugned order had been repealed by another order. Assuming that the explanation given by the appellant that the suit had been filed by one of the directors of the company without the knowledge of the director, who almost simultaneously approached the High Court under Article 226 is unbelievable. The question still remains whether the filing of the suit can be said to be a fact material to the disposal of the reputation on merit. We think not. The existence of an adequate or suitable alternative remedy available to a litigant is merely a factor which a court entertaining an application under Article 226 will consider for exercising the discretion to issue a writ under Article 226. The exercise of such remedy does not impinge upon the jurisdiction of the High Court to deal with the matter itself, if it is in a position to do so on the basis of the affidavits filed. If, however, a party has already availed of the alternative remedy while invoking the jurisdiction under Article 226, it would not be appropriate to entertain the writ. The rule is based on public policy, but the motivating factor is the existence of a parallel jurisdiction in another. But this court has also held in Chandran Krishna versus State of Odisha that even when an alternative remedy has been availed of by a party but not pursued, that the party could prosecute proceeding under Article 6 for the same thing. This court has also held when a party has already moved to the High Court under Article 226 and failed to obtain relief, then moved an application under Article 32 before this court for the same reason. Normally, this court would not entertain the application. But where in the parallel jurisdiction there is not a speaking one, or the matter has been entertained, the matter has been disposed of on some other law. This court has, in a suitable case, entertained the application. Instead of dismissing the liquidation, the ground the court may call up the party to elect whether it will proceed with the alternative remedy or with the application. Therefore, the fact that the suit had already been filed by the appellant was not such a fact that the suppression would have been affected the final discourse. Paragraph 16 and 17. As the issue of suppression was the only ground the High Court has rejected the applicant's plea for relief, we would ordinarily have set aside the order of the High Court and remanded back to the High Court for decision on it. But the matter has been argued on merit before us. We are in a position to dispose of the matter which we accordingly proceed to. We are of the view that the sale effected in favor of respondent number 6 cannot be sustained. It is axiomatic that the statutory powers vested in state financial must be exercised bona fide. The presumption that public officials discharge their duties honestly and in imparted by the established circumstances probabilize the abuse of that power. In such event, it is for the officer concerned to explain the circumstances which are set up against him. If there is no credible explanation of the matter, the court can pursue the cases were referred to. And at the concluding part of that paragraph, if they do, then it's for the parties. Another decision which is reported in 2002 volume 2, 2010 volume 2 SCC base 112.
You have not referred to this earlier? You have given certain decisions earlier. This is not referred.
These were not. This, on suppression, my lord, I have relied on two orders passed by the collegiate bench of this. My lord, paragraph 4 and 7.
Yes.
Fourth, my lord, referring to a case, my lord, reported in 1983 for SCC. My lord, it is in Welcome Hotel versus State of AP, Andhra Pradesh. The court held that a party which has misled the court in person notes in its favor is not entitled to be heard on the merits of the case. And then you must kindly take the reference. Here in this paragraph also without relying on referring to a judgment reported in Prestige, the case of Prestige Lights Limited versus SBI. It was held that in exercising power under Article 226 of the Constitution of India, the High Court is not just a court of law, but is also a court of equity. And a person who invokes the High Court jurisdiction under Article 226 of the Constitution is duty bound to place all the facts before the court without any reservation. If there is suppression of material fact or twisted fact have been placed before the High Court, then it will be fully justified in entertaining the question filed under Article 2. This court referred to the judgment in Scranton LD versus the Income Tax Commissioner and observed that in exercising jurisdiction under Article 226 of the Constitution, the High Court will always keep in mind the conduct of the parties who is invoking such jurisdiction. If the applicant does not disclose full facts or suppresses relevant materials or is otherwise guilty of misleading the court, then the court may dismiss the action without adjudicating the matter on merit. The rule has been evolved in larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving. The very basis of the writ jurisdiction rests in disclosure of true, complete, and correct facts. If the material facts are not candidly stated, or are suppressed, or are distorted, the very functioning of the courts would become impossible. My lord, I heavily rely on this. Here in this case, not only suppressed, rather the suppression was tried to be justified in the facts of this.
For the purpose of recapitulation, my lord, I am, my lord, placing only 2 or
You are
3.
appealing for the state.
My lord, read by Mr. Siddiqui, my lord. A previous occasion, my lord, Mr. Siddiqui, my lord, support of this, my lord, KMDA, my lord.
So you don't have anything
My
to
lord,
add.
my lord.
My lord, my learned friend, my lord, completed his submission, my lord.
Only, my lord, one line may I add. To recall, my lord, here, initially the writ petition, what was the suppression? It was pleaded, categorically pleaded, no so-called notice was issued.
That was issued,
But-
they have replied to that.
But the so-called notice was issued, the petitioner filed his reply, that fact has. And he was not, my lord, shown any repentance on this suppression, rather tried to justify.
My lord, for the purpose of recapitulation, my lord, some factual aspect. Because, my lord, I completed my submission long ago. So, my lord,
I have taken a detailed note of this.
my lord, only one document I will show your lordship. Because, my lord, my learned friend, my lord, completed his submission on threefold grounds. First of all, my lord, limitation. Secondly, my lord, the penalty which was demanded or asked for, that was the policy of the KMDA. Thirdly, suppression of material facts. So, my lord, first of all, lordship, I will show you, lordship, my lord, only one document. That is, my lord, the cancellation letter. That is, my lord, at page 123 of my writ petition. Have your lordship, my lord, got it?
123.
123 of my writ petition. This is, my lord, a letter dated 30th March 2016, issued by the Deputy Secretary State MMM M&M Unit KMDA to the Managing Director, Genesis Institute of Management of Technology, Southern Sir Rajanga Mendo. Subject: cancellation of allotment of land to Genesis Institute of Management of Technology. Sir, whereas it has been verified from record that plot number such and such under East Kolkata Area Development Project was allotted to Genesis Institute of Management of Technology by this letter number such and whereas physical possession of the land of plot number such and such was handed over to the Genesis Institute of Management of Technology on 4th May 2012, and whereas according to condition at clause 2.5 of the lease deed executed on 27 July 2012, the allottee are required to initiate the construction for setting up an healthcare related institute within 2 years from the date of execution of lease deed within July 2014, and whereas it has been further verified that the allottee has not started construction within the stipulated period, and whereas the allottee has failed to take up or construction on the plot which was allotted in favor of him, which is clearly in violation of the said condition of the lease deed, and whereas this is very important, and whereas the allottee was given demand notice to payment of penalty amounting to rupees 84 lakhs 26,880 for delay construction. So, my lord, principally KMDA agreed, my lord, to ask the petitioner to make payment of the penalty, and if the penalty is paid, the delay in making commencing construction or completing construction would be waived. Now, my lord, the question will come, and rather I put this question to myself, my lord, whether the KMDA can ask for penalty from, my lord, a charitable institution. My answer is, my lord, no, because the honorable division bench of this honorable court, my lord, in one case where my learned friend also appeared, categorically stated that KMDA cannot ask for any penalty from the charitable institution. So, my lord, kindly, my status, your lordship will find page 42, my lord. Page 42 of my lord, writ petition, wherefrom your lordship will find that Genesis Institute of Management and Technology, my lord, got it, my lord?
Yes.
A institute run under Genesis Educational and Charitable Trust, registered by book number 4, CD volume number 3, pages 4366 or 24405, being number such and such for the year 2009, pen number such and having his registered officer. So this document shows that it is a charitable institution, and the land was allotted for, my lord, the construction of, my lord, institution related to medical science. Now, my lord, I am, my lord, already relied upon one judgment that is unreported. My lord, in para 13, 14, 15 and 16, 17, it has been stated. Justice Somadar, Anil Mukherjee. Well, that is, my lord, this judgment was passed in MAT 839 of 2018 by the Honorable Justice Vishwanath Somadar and the Honorable Justice Anil Mukherjee. I place that judgment.
Give me a minute, please. Yes, yes, yes.
My lord, kindly I will look to.
MAT 839.
My lord?
MAT
MAT 839 of 2018. My lord, kindly I will look to paragraph 13 of that, my lord, judgment.
You've referred to this earlier.
My lord, not all the paragraphs, because my learned friend, my lord, raised the question,
17.
my lord, raised the question that in view of non-payment of the penalty, and it is the policy decision of the KMDA to ask for penalty. So this judgment is very much relevant, my lord, for adjudication of that issue, my lord. My lord, paragraph Yes, my lord, paragraph 14. We are in agreement with the learned single judge on the issue that the deed of license does not provide for realization of any liquidated damages by the KMDA in the event of failure on the part of the licensee to commence the construction within the 24 months time frame. The unreported judgment dated 8 May 2018 of the Division Bench in Kolkata Metropolitan Development Authority and another versus South City Projects Calcutta Limited and another relied upon by the appellants has no manner of application as the respondent number 1 writ petitioner cannot be equated with the developer like South City Projects Kolkata Limited, and that the contract does not provide for any amount stipulated as a reasonable estimation of actual damages to be recovered by one party if the other party breaches being the basis of liquidated damages. Penalty charges is punitive in nature and imposition thereof has to be specified in the agreement itself. There is no such provision in the agreement. We all, now my lord, this is very relevant. We also feel that penalty as per land and flat allotment policy of the authority cannot have any manner of application to the case of the respondent number 1 writ petitioner, since it is an educational institution operated by a trust without any profit-seeking motive and not a commercial organization governed only by the profit-making motive to be treated in the same line of applying such policy. So my status is also, my lord, in the same line that I am also an educational institution, and my lord, I am, my lord, operated by the charitable trust. So my humble submission before Lordship, my lord, that asking any penalty from the petitioner is not sustainable, is not tenable in law, in terms of the judgment of this honorable court. Now, my lord, my learned friend thereafter, my lord, argued that my claim is time barred. My lord, here, my lord, I have placed before Lordship on the earlier occasion that since long time I persuaded with the matter. My lord, I could not, my lord, take proper possession of the land due to the local disturbances. Thereafter, my lord, I applied for mutation of my name. I got mutation. And my lord, unless I got mutation, I cannot apply for sanction of the building plan for making construction. So, my lord, it was in the hand of the Kolkata Municipal Corporation, my lord. My lord, from the record, it shows that I have taken all steps immediately without wasting any time. But, my lord, if an authority, my lord, does not, my lord, mutate my name, does not sanction the building plan within a reasonable time, my lord, I put this question to myself, how can I start the construction? So, my lord, I have annexed all the documents showing that there was no latches or fault on my part. Rather, I was very much, and I am very much interested still now to, my lord, to commence the construction work for the educational institution. So, my lord, I rely upon one judgment, my lord. This is reported in, my lord, AIR 1984. Here, my lord, the Honorable Supreme Court, my lord, condoned the delay of 30 years. AIR 1984, Supreme Court, 866, paragraph 5. I am placing, my lord, paragraph 5. But it was contended on behalf of the appellant that even if the order of requisition was invalid as having been made for a purpose other than a public purpose, the third respondent was not entitled to challenge the same after a lapse of over 30 years. And the writ petition should therefore have been dismissed by the High Court. Now, if the only ground on which the order of requisition was challenged in the writ petition was that it was not made for a public purpose and was therefore void, perhaps it might have been possible to successfully repeal this ground of challenge by raising an objection that the High Court should not have entertained the writ petition challenging the order of requisition after a lapse of over 30 years. But we find that there is also another ground of challenge urged on behalf of the third respondent, and that is a very formidable ground to which there is no answer. The argument urged under this ground of challenging was that an order of requisition is by its very nature temporary in character, and it cannot endure for an indefinite period of time, and the order of requisition in the present case therefore ceased to be valid and effective after the expiration of a reasonable period of time, and that it could not under any circumstances continue for a period of about 30 years, and hence it was liable to be quashed and set aside, or in any event the state government was bound to revoke the same and to de-requisition the flat. This contention has, in our opinion, great force and must be sustained. There is a basic and fundamental distinction recognized by law between requisition and acquisition. The Constitution itself in entry 42 of list 3 of the 7th schedule marked a distinction between acquisition and requisition of property. The original Article 31 Clause 2 of the Constitution also recognized this distinction between compulsory acquisition and requisitioning of the property. The two concepts, one of requisition and the other of acquisition, are totally distinct and independent. Acquisition means the acquiring of the entire title of the expropriated owner, whatever the nature and extent of the title may be. The entire bundle of rights which was vested in the original holder passes on acquisition to the acquirer, leaving nothing to the former. By the observation, the concept of acquisition has an air of permanence and finality in that there is transfer of the title of the original holder to the acquiring authority. But the concept of requisition involves merely taking of domain or control over property without acquiring rights of ownership, and must by its very nature be of temporary duration. If requisitioning of property could legitimately continue for an indefinite period of time, the distinction between requisition and acquisition would tend to become blurred, because in that event, for all practical purposes, the right to possession and enjoyment of the property, which constitutes a major constituent element of the right of ownership, would be vested indefinitely without any limitation of time in the requisitioning authority, and it would be possible for the authority to substantially take over the property without acquiring it and paying full market value as compensation under the Land Acquisition Act. We do not think that the government can, under the guise of requisition, continue for an indefinite period of time in substance acquire the property, because that would be a fraud on the power conferred on the government. If the government wants to take over the property for an indefinite period of time, the government must acquire the property, but it cannot use the power of requisition for achieving that object. The power of requisition is exercisable by the government only for a public purpose of a transitory character. If the public purpose for which the
This
premises...
is requisition and acquisition.
No, my lord, here, at the last of this paragraph, the Supreme Court held, my lord, if it is found that the petitioner persuaded with the matter continuously, in that event, my lord, the length of time or period of time is not a factor. That's why, my lord, in this case, after 30 years, the requisition order was, my lord, challenged, and that was allowed by the Honorable Supreme Court of India. That is the, my lord, principle reiterated in this judgment. That is, my lord, only with regard to acquisition, difference of acquisition, requisition, all these things.
Where is that relevant part? Please show me.
My lord, page 870, my lord, at the middle portion, we must therefore hold that
Yes.
that the order of requisition, even if it was valid when made, ceased to be valid and effective after the expiration of a reasonable period of time. It is not necessary for us to decide what period of time may be regarded as reasonable for the continuance of an order of requisition in a given case, because ultimately the answer to this question must depend on the facts and circumstances of each case. But there can be no doubt that whatever be the public purposes for which an order of requisition may, the period of time for which the order of requisition may be continued cannot be an unreasonably long period, such as 30 years. The High Court was therefore, in any view of the matter, right in holding that in the circumstances the order of requisition could not survive any longer and the state government was bound to revoke the order of requisition and re-requisition the flat and to take steps to evict the appellant from the flat and to hand over vacant possession of it to the third respondent. So after 30 years, my lord, this case was, my lord, entertained and an order was passed in favor of the, my lord, writ petitioner. So my humble submission before your lordship, my lord, the length of period is not the relevant issue for adjudication of the point of limitation. My lord, if I am successful in showing your lordship that whether the petitioner continuously persuaded with the matter and whether the petitioner continuously requested the authorities concerned to give him and give it in an opportunity to, my lord, commence the construction work and to, my lord, complete the construction work because the delay which was caused not due to the latches of the petitioner but for the reasons beyond the control of the petitioner. So, my lord, what my learned friends, my lord, relied upon the judgment on the point of limitation, my lord. My lord, I will rely upon one judgment, my lord. That is, my lord, the subsequent judgment of the Honorable Supreme Court. That is, my lord, Tukaram Kana Joshi and others. That is reported in, my lord, 2013, volume 1, Supreme Court cases 353. Well, in this judgment, it relates to, my lord, land acquisition, but, my lord, the writ petition was dismissed solely on the ground of, my lord, limitation. Now, my lord, some paragraphs are very relevant. My lord, I am relying upon, my lord, paragraph 9, 11, 12, 13, 14, 15, 16, 17, 18, and 19. My lord, may I read for you, lordship? 9. The right to property is now considered to be not only a constitutional or a statutory right, but also a human right. Though it is not a basic feature of the Constitution or a fundamental right, human rights are considered to be in realm of individual rights, such as the right to health, the right to livelihood, the right to shelter and employment, etc. Now, however, human rights are gaining an even greater, multifaceted dimension. The right to property is considered very much to be a part of such new dimension. In the case of at hand, there has been no acquisition. The question that emerges for consideration is whether in a democratic body polity which is supposedly governed by the rule of law, the state should be allowed to deprive a citizen of his property without adhering to the law. The matter would have been different had the state pleaded that it has right, title, and interest over the said land. It, however, concedes to the right, title, and interest of the applicant over such land and pleads the doctrine of delay and laches as grounds for the dismissal of the petition appeal. There are authorities which state that delay and laches extinguish the right to put forth a claim. Most of these authorities pertain to service jurisprudence, grant of compensation for a wrong done to them decades ago, recovery of statutory dues, claim for educational facilities, and other categories of similar cases, etc. Though it is true that there are a few authorities that lay down that delay and laches debar a citizen from seeking remedy, even if his fundamental right has been violated under Article 32 or 226 of the Constitution, the case at hand deals with a different scenario altogether. The functionaries of the state took over possession of the land belonging to the appellant without any sanction of law. The appellants had asked repeatedly for a grant of the benefit of compensation. The state must either comply with the procedure laid down for acquisition or requisition or any other permissible statutory mode. There is a distinction, a true and concrete decision between the principle of eminent domain and police power of the state. Under certain circumstances, the police power of the state may be used temporarily to take possession of the property, but the present case clearly shows that neither of the said powers have been exercised. A question then arises with respect to the authority or power under which the state entered upon the land. It is evident that the act of the state amounts to encroachment in excess of the absolute power, which in common parlance is also called abuse of power or use of muscle power. The state, especially welfare state, which is governed by the rule of law, cannot arrogate itself to a status beyond one that is provided by the Constitution. Our Constitution is an organic and flexible one. Delay and laches is adopted as a mode of discretion to decline exercise of jurisdiction to grant relief. There is another facet. The court is required to exercise judicial discretion. The said discretion is dependent on facts and circumstances of the case. Delay and laches is one of the facets to deny exercise of discretion. It is not an absolute impediment. There can be mitigating factors, continuity of cause action, etc. That apart, if the whole thing shocks the judicial conscience, then the court should exercise the discretion more so when no third party interest is involved. Thus, analyze the petition is not hit by the doctrine of delay and laches, as the same is not a constitutional limitation. The cause of action is continuous, and further the situation certainly shocks judicial conscience. But kindly record, my lord, note one thing, my lord. In this case, no third party interest has been created till date. What my learned friend, my lord, relied on judgment, there, my lord, the delay was not condoned because in that case a third party interest was created. Here, my lord, no third party interest has been created because the land remains in the same condition. The question of condonation of delay is one of discretion and has to be decided on the basis of the facts of the case at hand. At the same, vary from case to case, it will depend upon what the breach of fundamental right and the remedy claimed are and when and how the delay arose. It is not that there is any period of limitation for the courts to exercise their powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in a matter after the passage of a certain length of time. There may be a case where the demand for justice is so compelling that the High Court would be inclined to interfere in spite of delay. My lord, in a compelling, my lord, the Honorable High Court can, my lord, interfere in case of delay. If, my lord, straightway a fundamental right of the petitioner has been taken away forcefully or illegally. Ultimately, it would be a matter within the discretion of the court, and such discretion must be exercised fairly and justly so as to promote justice and not to defeat it. The validity of the party's defense must be tried upon principles substantially equitable. No hard and fast rule can be laid down as to when the High Court should refuse to exercise its jurisdiction in favor of a party who moves it after considerable delay and is otherwise guilty of laches. Discretion must be exercised judiciously and reasonably. In the event that the claim made by the appellant is legally sustainable, delay should be condoned. My lord, kindly, my lord, note it. In other words, where circumstances justifying the conduct exist, in the event that the claim made by the applicant is legally sustainable, delay should be condoned. Clear case, my lord. In other words, where circumstances justifying the conduct exists, the illegality which is manifest cannot be sustained on the sole ground of laches. When substantial justice and technical considerations are pitted against each other, the cause of substantial justice is deserved to be preferred. For the other side cannot claim to have a vested right in the injustice being done because of a non-deliberate delay. The court should not harm innocent parties if their rights have in fact emerged by delay on the part of the petitioner. In SUVRA versus State of Maharashtra, this court condoned a 30-year delay. That judgment I will not rely upon. 30-year delay in approaching the court, where it found violation of substantive legal rights of the applicant. In that case, the requisition of premises made by the state was assailed. The High Court committed an error in holding the appellants non-suited on the ground of delay and non-availability of records, as the court failed to appreciate that the appellants had been pursuing their case persistently. Accepting their claim, the statutory authorities had even initiated the acquisition proceeding in 1981, which subsequently lapsed for want of further action on the part of those authorities. The claimants are illiterate and inarticulate persons who have been deprived of their fundamental rights by the state without it resorting to any procedure prescribed by law, without the court realizing that the enrichment of a welfare state or of its instrumentalities at the cost of poor farmers is not permissible, particularly when done at the behest of the state itself. The appellants belong to a class which did not have any other vocation of any business calling to fall back. This is, my lord, not relevant. Depriving the appellants of their immovable properties was a clear violation of Article 21 of the Constitution. In a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon them to rehabilitate such persons. The non-fulfillment of their obligation would tantamount to forcing the said uprooted persons to become vagabonds or to indulge in antisocial, anti-national activities, as such sentiments would be born in them on account of such ill treatment. Therefore, it is not permissible for any welfare state to uproot a person and deprive him of his fundamental constitutional and human rights under the guard of industrial development. My lord, in this case, my lord, the authority, my lord, demanded huge amount as penalty. My lord, my humble submission before lordship, my lord, that law, it is settled law that the authorities cannot claim penalty from the petitioner for, my lord, extending the time. My lord, I have categorically showed before the authorities, I earnestly requested the authorities give me a chance so that I can start the construction work. Without extending the time, the authorities, my lord, demanded huge amount which they cannot. And now, my lord, my learned friend argued that it is the policy of the KMDA to ask for penalty, and this honorable court cannot interfere. Now, my lord, I will show one judgment which my learned friend also, my lord, relied upon, my lord, which held that the honorable court in the my lord, authority of judicial review cannot, my lord, interfere with the decision of that authority, but the decision making process can be interfered. If suppose, my lord, the authorities, my lord, huh?
That is the law.
That is the law. My lord, I will, my lord, rely upon certain paragraphs of that judgment. My lord, it is nicely, my lord, held that, my lord, the policy making decision of the authorities, if it is irrational, illogical, it must be, my lord, set aside. So, in this case, my lord, what, my lord, Tukaram Kana Joshi, my lord, the Honorable Supreme Court of India held, my lord, that if I have got, my lord, fundamental right, if I am, my lord, I am, my lord, persuading with the matter consistently, my lord, if my right has been taken away, my lord, my writ petition cannot be, my lord, dismissed or solely on the ground of, my lord. Now, my lord, my learned friend also, my lord, relied upon this judgment. My lord, this is reported in 2022 Supreme Court cases 2, SCC 1.
There is a copy, I think. Niranjan Kundu versus State of West Bengal.
No, my lord, Punjab State Power Corporation Limited and other versus MTA Coal Limited. Didi,
Yes, I have read like-
You relied upon this. I'm trying to find out. Punjab State Power Corporation Limited.
Punjab State Power. Well, I am relying upon, my lord, the paragraph 28, 32 to 35.
28.
32 to 35.
32 to 36.
35. Well, may I read for your lordship? The issue with regard to legitimate expectation has been recently considered by a bench of this court to which one of us was a member. After considering,
KMDA has also relied upon these paragraphs.
Hello?
KMDA has also relied upon these paragraphs.
But
Like
the
32
data
and 33.
paragraphs, my lord, 31, 32, 33.
28, 32, 33, KMDA has relied upon.
Then, my lord, I am then 33, 34, 35, I am delaying. 33, my lord.
Yes.
It could thus be seen that while exercising powers of judicial review, the court is not concerned with the ultimate decision, but the decision-making process. The limited areas in which the court can inquire are as to whether a decision-making authority has exceeded its powers, committed an error of law, or committed breach of principle of natural justice. It can examine as to whether an authority has reached a decision which no reasonable tribunal would have reached or has abused its power. It is not for the court to determine whether a particular policy or a particular decision taken in the fulfillment of that policy is fair. The court will examine as to whether the decision of an authority is vitiated by illegality, irrationality, or procedural impropriety. While examining the question of irrationality, the court will be guided by the principle of Winsbury. While applying the Winsbury principle, the court will examine as to whether the decision of an authority is such that no authority properly directing itself on the relevant law and acting reasonably could have reached. Applying the opposite principle, it can clearly be seen that the decision of PSPCL dated such and such cannot be questioned on the ground of illegality or procedural impropriety. The decision is taken in accordance with Section 11 of the Act and after following the principle of natural justice. So this is the factual aspect of the case is altogether different, my lord. Paragraph 33, my lord, the principle has been reiterated, my lord. When, my lord, this honorable court can, my lord, exercise the judicial review. In that case, my lord, it is held that the decision was taken appropriately. But my humble submission before Lordship, my lord, in this case, my lord, it shows the biasness, the illegality, the illogical, the impropriety of the KMD authorities in demanding a huge amount as penalty for extension of time to commence and complete the construction work, since it is, my lord, charitable institution, and, my lord, the construction is being, my lord, to be commenced for, my lord, the welfare of the students, not for, my lord, any profit earning purposes. So that's why, my lord, the cancellation of the, my lord, authority, my lord, is absolutely vitiated by illegal means, and, my lord, it's liable to be quashed, my lord. That's all, my lord.
That's all. Reserved. Judgment reserved.
আগে অনেকদিন বলা আছে,
Argument concluded, judgment
অনেকদিন
reserved.
শুনেছেন ব্যবস্থা আর
Argument, এস করবেন না। এগুলো ভেতরে অনেকগুলো জাজমেন্ট আছে সাতটা। There is a 12 o'clock specially fixed matter. No one. Petitioner?
My lord called Patil.
12
My lord
o'clock
called Patil.
fixed matter. Where are the petitioner and the
My lord, I'm for the petitioner, my lord. My senior is busy in another court. I'm praying for a short passover, my
was
lord.
a 12 o'clock specially fixed matter, isn't it? I'll
Yes,
dismiss the matter.
Yes, ma'am.
Come back again. I will not consider anymore.
My lord, then allow me to proceed, my lord.
Yes?
Allow me to proceed, my lord.
Where is the Jila Parishad? Yes? Where is the report? Have you served a copy to learned counsel?
No, my lord.
Yes, they are agreeing to restore your land.
My lord, but I didn't have any permission, my lord. I never agreed to give my land to them because it is
They
my.
are agreeing to restore your land to the original position. And you
My
are
lord,
agreeing
allow the
to that.
report. My lord, allow the report to serve on us and let the matter appear tomorrow, my lord.
What is this? It is specially fixed in your presence.
Apology, my lord. My senior is not there, my lord.
Yes?
My senior is busy in another court, my lord.
Next month, you are not interested at all. None appears. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th April. Next matter.
Sir, 13, my lord, 13 and 14.
Yes.
This relates to the settlement of Ferighat. I took the initial point that this repetition is not at all maintainable because of the fact it's coming under manual of 1991, and this particular manual is for the purpose of implementation of the Land Reforms Act. Hence, that coming under section 2R of the West Bengal Land Reforms Tenancy Tribunal Act. That's why it's a specified act, and this notice, auction notice, cannot be challenged before this writ court by filing a writ petition. This was my point, initial point. The maintainability of the writ petition was under question by me, my lord, and towards that, my lord wanted to have that directed me affidavit in opposition be filed on that score. So I have dealt with my affidavit in opposition, touching the point of maintainability as also on merit. And Mr. Betal is the selected candidate. He was the successful
Who is the petitioner
auction.
for the first matter?
But I am for the petition.
Mr. Betal is the petitioner in the second matter.
No,
No,
Mr.
my lord, I am the
Private respondent,
in the
successful
first
bidder.
matter. Chief respondent in the first matter. And particularly, my lord, in the first matter, if my lord takes up para 13 of the writ petition, they admits, my lord, we are the Boatsman Cooperative Society.
Yes.
Para 13. Para 13 of the first writ petition, that is WPA 8464 of 2022. Para 13 of the writ petition.
And that is on merit. That is on merit.
Mr. Dhar is saying about maintainability. We will argue, my lord, I will indicate, my lord, regarding my status in para 13, they say, my lord, the petitioner states that so far as the ferries where the petitioner participated, there the private respondent also participated as a cooperative society framed by the boatman or partner community.
Merits.
So, yes, it is on merit.
The
My lord,
maintenance is being taken up first.
Yes. In my case, my lord, only they registered that we are not the, my lord, a boatman or boatsman cooperative society. But in para 13, my lord, they say that we are the, my lord, partner community, a boatsman society in para 13.
On maintainability.
Yes, maintainability. Let me place my that affidavit. Kindly come to my affidavit. Before I proceed to the affidavit in opposition, let me first take your lordship to their writ petition, which is
respondent number?
I am the respondent number 123. my lord, their notice which is annexed in page 21 and my lord has got it. ই-নিলামের জন্য বিজ্ঞপ্তি সরকারি ফেরিঘাটগুলির বন্দোবস্তর জন্য 2022
Give me a minute,
মানে
I have to কেটে দিন তো huge voluminous record. এটা কেটে দিন তো। Respondent number 5 is the state.
my lord is
First matter.
Item 13, I am first matter, I am for the respondent number 5.
yes.
That is successful, my lord.
13 I am for the state, 14 Mr. Dhar is for the state.
Oh, so you are mentioning in 14. You're
Yes.
I thought it was 13. 14 is 5022. 13 also you have filed Mr. Bandyopadhyay filed
Yes,
the LFP.
yes.
Reply is filed in both the matters. This is 8464 is the first matter. Second read petition. 8464. দুটো ফাইল একসাথে হয়ে গেছে। I believe this matter will take some time.
My lord, this will
Because,
take some time.
30 have to take up mentioned matters.
Kindly, my lord,
Take some time, substantial.
my lord, they have been enjoying the interim order, my lord, since long. My lord, kindly, my lord, take it up.
But I am suffering the interim order.
I
For
understand.
last
Petitioner is
more than,
enjoying interim order, private respondent also enjoying interim order. Because they had
no,
deposited.
I am not enjoying any interim order.
No, return now. My lord, private
Amount
respondent
was
has my lord
returned,
deposited the
always
amount.
subject- After being successful, I will certainly deposit. But the purpose was for
ওকে বলা
granting,
হচ্ছে না।
purpose was for granting me the operation of the ferry guard.
Back the amount, I think.
Yes, he has got back the amount.
That is
Yes.
sent to bank account or something.
Yes, yes.
Let it be extended for a limited period because it will take some time.
Date fix koriye na.
My lord,
Yes.
is a tender process of 2021, my lord.
I
Means, my lord, then I am suffering.
be prepared with
আমি
mental
থাকতে পারি না।
because this point.
Yes, yes, my lord. Completely prepared. Completely prepared with the maintainability.
Other benches earlier, so I don't think it's a new issue.
No, no, my lord. Decided by the other bench. This plea taken by the my lord, the state in the other benches also, my lord. My lord, decided against them.
You have the judgment.
Yes, yes, certainly, my lord.
Are you aware of these judgments, please? Why did you give the reference?
সুব্রকমল মুখার্জি, জ্যোতির্ময় ভট্টাচার্য।
জাস্টিস সুব্রমণ মুখার্জি
হুম।
না জ্যোতির্ময় ভট্টাচার্য জানি না।
দিয়ে দিচ্ছি তোমার।
No, no, I'll show that just my lord, the judgment passed by Honorable Justice Subramanian Mukherjee, my lord, sitting in a division bench, has not considered the previous division bench judgment as also the provision of law.
It has to be sent to a larger bench in that case.
No, no, that I'll show.
Separate division bench judgment.
My lord, I'm not, my lord, at this moment is my lord, expressing.
That's why I've requested learned counsel to
Alright.
hand over the copies so that you can go through them when they meet them.
Certainly, my lord. But I'll just, my lord, make a list of the judgments, my lord, that I'll be placing, my lord, and my lord.
And please make it over to.
Certainly, certainly, my lord.
My lord, kindly fix up at it.
In the
My lord,
next date.
kindly fix up at it.
Prior to next date, my lord.
17th April.
Budvar. 17th April.
Mr. Pan, 17th April.
17th
Mr.
April.
My lord, I have no difficulty, my lord, let it be fixed as specialty. Otherwise, my lord, it will be gone to the bottom, my lord, as hearing, my lord only takes, my lord, at 3:30 hearing matter or 3 p.m. hearing matter.
It's appearing as motion.
It will appear as motion.
It is appearing already. It is not appearing in the hearing.
It was gone to the hearing.
Your Lordship mentioned that though it is ready for hearing, it will appear as motion.
Her learned counsels for the parties. Let the matter appear under the same heading. On 17th April.
My lord.
Paragraph, the interim order granted earlier is extended till 31st May or until further orders, whichever is served.
My lord, up to April, my lord.
Yes?
Interim order up to April. Interim order up to April.
Give for a little more time because it takes some time.
My lord, nobody knows, my lord, who is now operating. That is the
Loss,
difficulty.
Mr. Betal.
My lord,
Well, his money has been secured already, my lord.
Secured, no, returned.
Grateful to you.
Yes, 16.
15 and 16 are analogous matter. Your lordship was 15 and 16 are both will be taken up together.
Yes.
That is the lordship last transaction of the order.
And I appear for item number 16 for the state.
Lordship,
I am in 16, my lord. I am for the writ petitioner. Your lordship passed an order for my lord initiation of process under section 10(3). The process was initiated and my lord, the matter referred to the my lord 10(3) authority. My 10(1) was completed, demarcation was done. The matter was referred to the my lord 10(3) authority. Now, my lord, he filed an application for recalling of your lordship's order, where your lordship directed to complete the demarcation and conclude the logical conclusion of the 10 proceeding. The proceeding was concluded and 10(3) proceeding was, my lord, initiated, and the 10(3) proceeding is going on. In the meantime, my lord, after filing of my writ petition, alleging the illegal construction made by the private respondent in my writ petition, he filed a writ petition, that is first on item number 15, alleging that this property is not belongs to the PWD authority. That was my lord, earlier, my lord, that was been acquired and subsequently it was released. My lord, he filed a petition stating that this property is not. My lord, my grievance is that everything will be decided by the 10(3) authority because the hearing is pending before the 10(3) authority. My lord, I have the document.
may I petition? Now everything has been made by the false submission and obtain an order from your lordship. My submission before lordship, my lord is kindly see the order which has been passed by my lord Justice Joy Sengupta in this matter, in my first item. What is my prayer?
Matter was disposed of.
After your lordship was only directed to complete the demarcation, and if it is found that there is a government landed property, the proceeding under section 10 will be.
Why is the second matter appearing with the
Because he filed an application for recalling of my lord's order.
My lord is now, my lord, now I have to allow to.
This is my lord.
My lord, may I submit one thing? My first writ petition before moving the second writ petition. My lord,
after my writ petition.
My lord, I have to allow. Why you are so much?
My lord, my writ petition.
My lord, is the,
you are in the second matter.
yes, my lord. Now this, my lord, this so far my first matter is concerned has been filed. What is my prayer? Prayer is very limited. A proceeding under section 10(3) of the West Bengal Highways Act was initiated in 2015. That is the counter blast petition. I challenge that proceeding before the Honorable Justice Devanshu Bhosar, and my Lord Justice prima facie found that this is the counter blast petitions. Now the matter, another, my lord, the matter which has been, my lord, obtain an order for eviction of my front portion of the land. Against that order, my lords, I file a contempt. Both the matter had together in, my lord, the proceeding. At the end of the proceeding of, my lord, during the proceeding of section 10(3) in 2017, the executive engineer has come to conclusion on the basis of the information supplied by, my lord, the LA collector, that they have no documents in respect of acquisition of that proceeding. And proceeding, my lord, which was initiated in 1946, that has been, my lord, stood, my lord, the cancel in 1954. So now, kindly, only one document and prayer is very limited. How the, my lord, twofold submission. If the land is belong to PWD, so now, my lord, I have no case. So now the executive engineer has come to confusion that they are not confirmed whether land is PWD or not. That's why they wrote a letter to the LA collector to confirm. Then we can proceed the proceeding. That proceeding is still pending. in 90, my lord, this is the 2017. Now I moved a writ petition before your lordship, obtain an order 466/2022 against my learned friend's clients. Now the counter blast petition has come before your lordships. That is his second writ petition. So, my lord, the second petition, second writ petition. I, after knowing that no notice has been served, I file a recalling application. Well, I am coming. Now, prima facie, your lordship has heard that application in presence of my learned friend, called for a affidavit, and the mentality point is opened. So, till this date, neither any affidavit of opposition has been served in spite of your lordship's order, and no, my lord, the information, my lord, got from the higher authority. Now, subsequent during the pendency of my writ petition, so now the authority concerns come again, my lord, the supply the document. Yes, notification.
There was a direction for affidavits.
Yes, where is the affidavit?
My lord, with regard to recalling application, your lordship was directed to complete the demarcation proceeding. And my lord,
there was a direction for affidavits.
Affidavit.
My lord, my affidavit is ready, but it is not required to file.
So you don't want to file an affidavit?
Then I will proceed.
I'll record that.
I will.
You don't need to file an affidavit in opposition. Second.
Yes, my lord, this stance should be correct. My lord,
it was affirmed within the time as your lordship, and it was my lord, something what it was, my lord, it was affirmed on 24th of April
Are you
2020.
filing an affidavit in opposition in Can 1 of 2023 in the second matter?
Well, this is my affidavit opposition.
Are you say it's not necessary, so are you filing it?
My lord, your lordship, kindly see the affidavit in opposition. My lord, kindly see the
Are you filing it, sir?
well, I am
Yes or
filing,
no?
I'm filing the affidavit in opposition. My lord, your lordship, kindly
now,
see.
my lord, I have to, my lord, giving a chance to my
No,
lord. Apart from this,
Apart from this, this is the mentioned matters time.
no,
so I have to
correct,
give an
correct.
agenda.
My lord, let them either, my lord, next,
I have
only one limited prayer.
I have an application in their application in their my lord petition for addition of party. My lord, the application number is my lord.
Matter only. I am
my lord 90 my lord 55 my lord. I have
Not a party to in the.
no. Why?
My lord, after filing of writ petition, he filed this subsequent writ petition when the demarcation was concluded, and the record of right shows that this property belongs to the government, and government 10-1 proceeding was completed. The matter is pending before the 10-3 authority.
Yes, so there is no stay at the 10th.
Yes, my lord, my what is my today, my lord, my peer lordship, let all the grievances of my learned friend and mine, but the 10th authority will decide within a time frame before your lordship.
That's why my lord Justice Joyce here to hell. Why the second proceeding?
My lord, 10th
Parallel proceeding is the bar.
The court has not held anything. It was only a submission which is recorded.
Yes, that is my submission.
Nothing is held.
No. I only my limited
my lord,
prayer.
as on date, the record of rights stand in the name of government. In the
My lord, that is under challenge before the LRTT.
Have you received an application?
No, nothing.
This
Nothing.
addition of party application?
Nothing.
My lord, my lord, in this
Nothing. No evidence.
it has not been served.
Nothing. No.
I am having a copy of the application for addition of party, and I also file a contempt application in this matter.
Have you served the state?
Nothing.
State with regard to my addition of party.
Yes.
I'm not blessed with anybody's any copy.
You are appearing in which matter? The second one or the first matter? You are in the first matter or in the second?
First. My learned friend.
Second. The second matter. Please exchange your copies.
I have exchanged. Everything I have exchanged, but I have not just now today. I have.
What is not received?
Halder has given me the
Mala, I have.
With regard to my first
First, second, shop.
Submission of party application, please serve the others.
Show me to that. Show me. My lord, may I submit one thing, my lord? Since the affidavit in my lord the Can, which has been filed in connection with the my matter, though he is not interested party in this matter, only my limited prayer before your lordship. Now I want to file exchange of the my lord affidavit. One. Second is the affidavit in opposition which has been filed by my learned friends clients, my lords. I want to my lord, as per your lordship direction, I have to
Find a reply.
reply. Now, second, my lord, only one limited prayer. So now I have come to know from the SDO at the second proceeding, as per your lord's order, SDO again wrote a letter to the land acquisition officer on 12th of February 2024 for confirmation of the land is belong to PWD or not. So now my submission before your lordship very limited. Even my learned friends, though I have the document notification.
Unless the addition of party application is considered, Nothing else can be done in this matter, right?
No, I am correct. My lord, you
So are you conceding to this application? Do you agree to add him as a party in the?
lordship, as your lordship, I want to
I
find
can
the.
allow it on consent in that case.
No, my lord, because of that, it is the counter blast petition, that is the division bench. In his matter, I was appeared in the respondent in Koviruddin, that is the second item. Counter blast writ petition is not meant.
Do you have any objection? to
Lordship,
the
it is, I
additional
have
party?
to objection. I have to find the objection.
The applicant in Can 2 of 2024 in connection with WPA first matter is 9055 of 2022 is directed to serve copy of the application upon both the parties
Already petition was served. Petitioner was served the copy of the application.
upon the respondents.
With petitioner was served the copy of the application.
To serve the
Other
respondents, upon the respondents and file affidavit of service on the adjourned date. Paragraph. Affidavit in opposition
No, I have not been sharp.
filed.
এক্ষুনি তো কপি দিলাম
Addition of partyটা দিয়েছিস দেখ
অ্যাডিশনাল পার্টি
আর opposition
Opposition. Affidavit in opposition used in Can 1 of 2023 in connection with WPA 8556 of 2022 is taken on record. Paragraph.
Everything is pending before the 10-3 authority.
Private respondent in the said writ petition seeks to use an affidavit in reply to the same paragraph. Let these matters appear under the same heading on 18th April.
that
ওটা contempt hearing আলাদা করে দিন। Contempt টা বিধি করা নেই, contempt টা শুধু ওটাতেই হবে। মানে একসাথেই আসুক, কারণ আলাদা করে হবে না, যেভাবে আছে সেভাবে থাকবে, কিছু করতে হবে না, যেভাবে আছে থাক, খালি অ্যাপ্লিকেশন টু টাইপ।
এই সেকেন্ড ম্যাটার কি প্রাপ্ত
Pension matters.
আমি তো লক্ষ্মীনাথ ভট্টাচার্য matter, we get to second matter. I am led by Mr. Devbot Sara. Second matter.
So this is the matter regarding.
Yes.
This is the matter, Lordship. My way, ingress and egress has been obstructed.
Have you served?
Lordship,
Where is your service?
as per
Upon the private respondents, please show me.
yes. After filing this disposition, Lordship, they called me for the ADM called me for demarcation, Lordship. I have participated over there, Lordship. After that, they didn't took any step.
Item number 16, item number 16, 15 I am appearing along with Mr. Raj. Sir.
He has to be in court, isn't it? I do not even know where he is. I have not seen him at all.
He is on level code number 9, that is
I have not seen him in the morning at all.
code number 9, he is in there.
No, no, give your name. Yes, Mr. Bandhavadi, you are appearing in this matter.
Lordship, kindly see this.
Is it PWD land?
Lordship.
This is a communication for demarcation.
I have no such instruction, my lord. He made representation before the authority. Highway Act, my lord, let it be
Copy of this
considered by the
letter.
authority.
It is your executive engineer.
In the month of December, Lordship. This is in the month of December. Now March.
Where is your representation?
Kindly page 23. 23 of my writ petition.
It has been sent to the my lord for demarcation before the BLRO, my lord. After demarcation, my lord, the steps will be taken.
So let it be disposed of on this road. Affidavit of service. None appears for the private respondents despite service. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondents are raising unauthorized construction by encroaching upon PWD land adjoining their plot, thereby obstructing their egress and ingress. Is it? Pursuant to a representation submitted by the petitioners before the executive engineer, PWD, Barashat division on 4th May 2023, the executive engineer, by a letter issued on 8th December 2023 to the Additional District Magistrate and District Land and Land Reforms Officer, North 24 Parganas, Barashat, requested the latter, LATTER, to instruct the Block Land and Land Reforms Officer, Barashat, Roman 1, to make suitable arrangement for demarcation of the plot in dispute in order to ascertain whether the said plot belongs to the PWD. Paragraph. Learned counsel for the petitioners submits that the concerned authority be directed to conclude the proceedings within a stipulated time frame. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since the Block Land and Land Reforms Officer has been requested for demarcation of the plot in dispute, PLLRO is not a party to the writ petition.
No, Lordship.
State is representing
District Magistrate.
District Magistrate, Executive Engineer.
your lordship.
No,
Your lordship
PLRO
can they are
Please add. Yes, please add. The Block Land and Land Reforms Officer, Barashat Roman 1, being the 12th respondent hearing at ad proceeding, be directed to conduct such demarcation upon service of notice to the petitioners and the private respondents and submit a report to that effect before the third respondent within 1 month from date. Stop. In the event encroachment upon PWD land or any portion thereof is found upon demarcation, the third respondent be directed to.
Well, your lordship has directed the respondent number 4.
But this communication is by the third respondent.
Well, thereafter, my lord, I have received, my lord, I have no knowledge. My instruction, my landed to the respondent number 4, my lord. He has also
Third na kore fourth.
3 and 4. 3 and 4.
3 and 4 দুজন হয় না একটা
প্রথমটা করবে এটাও তাই
14.
any portion thereof, the fourth respondent
Western
be
engineering
directed
করবে
to
এটাই নিয়ম
initiate proceeding under section 10 of the West Bengal Highways Act 1964 and take the proceeding to its logical conclusion within 2 months from the date of receipt of the report.
Lordship, can you make it 1 month already in the month?
Why not?
Evidence has to be led. 10(3) is there. Upon affording reasonable opportunity of hearing
আরে করলে হয় না, তো সময়
all the to the interested persons, including the petitioners and the private respondents, comma, in accordance with law. Disposed of which line? একদম শুরুতে করুন, on prayer of the petitioners, comma, liberty is granted to complete the block plan and land reforms officer, comma, Barashat, Roman 1, as respondent number 12 in the writ petition. The cause title of the writ petition be amended accordingly. Next.
I beg to appear for the petition.
73, my lord, Mr. HON'BLE is appearing for the state.
My lord, affidavit of service. My lord, on the government land, my lord, maintained by the PWD, my lord, there is a encroachment by the private respondents.
Have you served the private respondent?
My lord, I have served, and my lord, the answering respondent authority is, my lord, the respondent number 2 and 3, executive engineer and assistant engineer. But my lord, in the similar,
Lord, may I submit something? Lord, can I seek for the instructions from the respondent concerned, my lord?
Why do you need instructions?
Because, my lord, or let me lord the representation be considered, my lord. One representation is also pending.
Yes. Let the authority decide. Instructions will really not help, isn't it?
my lord, one thing may I submit, my lord, because my lord, in the similar type of, my lord, this allegation, my lord, the concerned authority, my lord, has taken the legal steps in the provision of section 10 of the West Bengal Highways.
Concerned authority will take.
My lord, but my lord, in this case, the problem of the authority is, my lord, the kindly, my lord, the private respondent, my respondent number 22, my lord, one of the encroachers are, my lord, the local party office of the, my lord, the ruling party.
So
that is the problem of that authority for not
Don't have any
taking
instruction
any
for
step.
that.
My lord, that is the main.
So do the needful.
My lord,
Otherwise they'll face contempt.
my lord, my lord.
Is this a privileged respondent?
My lord, privilege na, they is the encroachers, but the
Why are
influence,
you speaking for the
he
state,
is
sir?
so much influence, my lord. That is why, my lord,
Let
the
the state
authority,
decide.
my lord, did not,
Let
my
the
lord,
state take a call. Why are
my
you
lord,
speaking for the state?
my lord. That is my grievance, my lord. I am just.
22 is only one of the respondents, not a privileged person.
No, no, no.
Then where is
Because
your
my lord,
representative?
9 to 20,
Yes.
all are
Let the state
encroachers.
take a call.
My lord.
Where is your representation?
Representation, my lord, page 16, 16, my lord, to the executive engineer, and my lord, 19 is, my lord, the assistant engineer.
The same representation?
My lord, same representation.
It should be by the assistant engineer.
My lord.
Affidavit of service. And none appears for the private respondents despite service. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD land adjoining their property, thereby obstructing their egress and ingress. That is your claim. The petitioners submitted a representation in this regard before the concerned authority on 11th September 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the third respondent be directed to consider the representation in accordance with law. Paragraph of the above action is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of which judgment. Next.
Wait, please, Your Lordships. My lord, I appear on behalf of the petition.
2002 এর lease.
My lord, in terms of the 2002 rules, my lord, a long-term mining lease was granted in favor of the petitioner in the year 2008. My lord, within the stipulated period, my lord, an application for renewal was made. My lord, that, my lord, having been rejected, my lord, I came before this honorable court. A coordinate bench directed that, my lord, my renewal application be considered in terms of the 2002 rules. My lord, now, my lord, again, it has been rejected. The impugned decision is at page 106. My lord, recourse has been taken, my lord, to the amendment of 2016 and more particularly to Rule 61, my lord, thereof. My lord, kindly comes to page 106, 19th September 2023.
Order, yes.
My lord, kindly come straight away to page 108. Decisions with reasons at the bottom.
Yes.
Now, when the petitioner filed the application on 1st December 2012, the West Bengal Minor Mineral Rules 2002 was in existence, but thereafter on and from 29th July 2016, two set of new rules, namely the West Bengal Minor Mineral Concession Rules 2016 and the West Bengal Minor Mineral Auction Rules 2016 came into existence. The legal proposition as laid down in the Rule 61 of West Bengal Minor Mineral Rules 2016 stated, then all applications for mining lease, my lord knows this, my lord, I need not place this, but as stated earlier, as no grant order or letter LOI or any government order was issued in favor of the red petitioner before the coming into force of the 2016 rules, so the application of the petitioner has automatically become ineligible as per the prevailing laws. Moreover, Rule 61 of the West Bengal Minor Mineral Concession Rules has been framed in consonance with 10A of the Mines and Mineral Development Act. All applications received prior to the date of so-and-so shall become ineligible. As per Rule 62(1) of the West Bengal Minor Mineral Concession Rules states, West Bengal Minor Mineral Rules 2002 is hereby repealed. So on and from 29 July 2016, the West Bengal Minor Mineral Rules has already been repealed. Further, as per Rule 62(2) of the West Bengal Minor Mineral Concession Rules states, notwithstanding such repeal, anything done, any action taken, any prosecution started under the new rules shall be deemed to have been validly done or taken or started as the case may be under the corresponding provisions of these rules. Moreover, the application for renewal of long-term mining lease of petitioner was already refused on 2nd November 2012 of the additional district magistrate. Hence, action was already taken and the said action fell under Rule 62 of the West Bengal Minor Mineral Concession Rules. It may further be mentioned that as per so-and-so West Bengal Minor Mineral Concession Rules, wherein it is stated the grant of prospecting license not relevant. So we'll kindly come to page 111. So after coming into force of the 2016, lease can only be granted through auction. Now, Lord, kindly, Lord sees, kindly come to page 106 once again. 107, sorry, my lord. 108, my lord, the top paragraph. He is conscious of the direction passed by this honorable court in the first paragraph. In the meantime, the petitioner preferred instant writ petition to get benefit of renewal of mining lease. In the said clause, there was a provision for renewal of mining lease as per Rule 12 of the 2002 rules. The petitioner filed an application for renewal of his mining lease as per 12(1). The matter was undated after the enactment of 2016. Suddenly, the matter was put up before Honorable Justice so-and-so on 17 July 23, and the matter was finally heard and disposed of with a direction upon the undersigned to consider and dispose of the petitioner's application for renewal of mining lease in accordance with Rule 12 of the Minor Mineral Rules 2012 within 60 days. Why I place this is because it's not in that, not in ignorance of a direction passed by this honorable court, and order is passed. And the authority holds by interpretation of a rule according to his own wisdom in a particular way. He has been asked to do it in accordance with a particular rule, interpretation whereof is cited in the decision itself. Yet, my lord, he digresses, and my lord, he takes an opinion which is divergent to the direction passed by this honorable court. Now, my lord, a coordinate bench of this honorable court, my lord, had the privilege, my lord, of dealing with the issue, and my lord, directing the authorities that here is a situation where time and again The time and again issue cannot be relegated back to the authority for reconsideration and directed, my lord, that now this has to be considered and renewal was granted. Lord, kindly comes to paragraph 2. The petitioner so and so is a resident of village Bardwan. On the basis of his application dated, the Deputy Secretary Government of West Bengal so and so issued a grant order for long-term mining lease for extraction of sand on so and so 5 acres of land in river bay of Damodar on the basis of grant order of additional district magistrate, executed a final lease, and the same was registered by the registering authority BN. On so and so, the revenue officer handed over the leasehold land. Now, my lord, kindly sees that the petitioner said during the continuation mining operation, he filed an application for renewal of mining lease under Rule 12(1) of the Minor Mineral Rules by maintaining all formalities. The petitioner said by memo number so and so, additional district magistrate, land reforms officer, Bardwan rejected the state renewal of mining lease application under the amended provisions of West Bengal Minor Mineral Rules 2012 with a notification number so and so with effect from 2011 as the grant of mining lease riverbed is governed by Rule 16B of the 2016 rules. My lord, kindly now, let come directly to page, para 9. I'm sorry, my lord, paragraph. No. Huh? But kindly come to internal page 4, paragraph 6. The respondents were not represented by the learned counsels at the time of argument. Therefore, this court proceeds to decide the instant application on the basis of submissions made by learned advocate for the petitioner. The issue relating to applicability of the amended provision of the rules 2002 came for consideration before division bench in so and so decided on 4 July 2014, where the honorable division bench of this court was pleased to hold that the decision taken by the concerned authority in refusing to grant renewal of lease in favor of the petitioner was illegal, and according to the impugned decision was set aside. The concerned authority was directed to consider petitioner application for renewal in the light of provisions contained in Rule 12 of the Rules 2012 and take its ultimate decision in this regard without applying the provisions of the amended rules which have already been declared as ultra vires. The division bench also held that until such decision is taken, the petitioner's lease was deemed to be extended. Upon payment of royalty rent is realizable from them as per Rule 20 of the Rules 2002 for the period during which lease continued as per the deeming provision of 2002 rules, and the fate of their application for renewal would be ultimately determined by the prescribed authority in a manner indicated in the judgment in so and so. On 8th May 2023, a coordinate bench held that the order of rejection of renewal of mining lease cannot stand as the order was passed on the basis of amended provisions of 2011 Minor Mineral Rules 2012 that was declared ultra virus. This court in Shopon Sarkar. Then paragraph 9, the respondent number 2 and 3 are directed to grant renewal of mining lease in favor of the petitioner on the basis of his application in 2013 respect of 5 acres of land. But another decision, Shambhali Hazara. But kindly come to my lord, paragraph 2 and 3. Page 2. But here also, my lord, on page 1, it is recorded that my lord, an application for renewal was made. The last 3 lines. Before expiry of the extended period, petitioner by letter number so and so applied for renewal of the said lease, which was scheduled to expire on 28th August 2016. Now, by a letter dated 22nd February 2016, issued by the ADM Bardwan, his prayer for renewal of lease was kept in abeyance till disposal of mandamus appeal number so and so. The petitioner has annexed an order sheet of a proceeding initiated in respect of prayer for renewal of mining lease on the basis of an order passed in so and so in Payal Chaudhary. In the aforesaid petition, a coordinate bench of this court with the order dated 20th August 2014 directed the respondents to decide and dispose of the application for long-term mining lease by 6 weeks upon giving opportunity of hearing to the petitioner or his authorized representative and to pass reasoned order and to communicate the same within 2 weeks from the date of passing of the order. Finally, with the order dated 7 July 2015, long-term mining lease was renewed in favor of the Payal Chaudhary petition and so on the following grounds. Let I pause here for a moment. So on a direction passed by this honorable court for considering the application in accordance with the then prevalent rules when the application was made, the authorities acted. And this is in respect of the Selsom district. Then the renewal order is quoted. I need not place this. Kindly now come to page 9, internal page 9 of the order. Having heard the counsels, second paragraph, having heard the counsels for the parties and on careful perusal of the entire materials on record, it appears indisputably that the petitioner was a lessee of a mining lease. The said lease was initially for 5 years. Thereafter, it was extended for another 5 years, and then on 8th February 2016, petitioner prayed for renewal of the lease. On the date of submission of the prayer, the West Bengal Mining Mineral Rules 2016 did not come into effect. These rules came into force from the date of their publication in the official gazette. The rule was notified in the official gazette on 29 July 2016. The said rule came into force on 29 July 2016, and before the said rule coming into force, the petitioner already took step for renewal of the mining lease. The petitioner was also directed to deposit a sum of rupees so and so, and the said amount was deposited and so on the basis of order passed by the ADM. The petitioner and one Payal Chaudhary, whose case was decided in favor by order dated 7 July 2015, were directed to obtain environment clearance within 3 months from the date. Therefore, it is crystal clear that even after Concession Rules 2016 came into force, the respondent authorities acted on the application made by the present petitioner. In view of such circumstances, this court has no alternative but to hold that by specific act and by the respondent.
I think can be distinguished from the present matter. Here, the authority had taken steps pursuant to the application.
Lord, the only thing is that
they had asked for environment clearance. They had asked for the
my lord.
But so this is little different from the other matter.
Only thing is that whether the state can take different stand in two different cases. Our court has held that the state is an ideal litigant. Lord has to take consistent step. When one coordinate bench directs, you consider his case in terms of 2002 rules. Lord, that petitioner need not had to come in the second round of litigation because an order was passed in a favor granting renewal. In respect of the Selsom district.
Earlier orders in this matter.
My lord.
The earlier 2 orders of coordinate benches in this matter.
Yes. Lord, please. Chaudhary Yes, please. Page 92. And my lord, kindly come to page 93. Lord, paragraph 5. It is not in dispute. It is not in dispute that long-term mining lease was granted by the state in favor of the writ petitioner by permitting them to extract sand from the riverbed in respect of land mentioned in the lease deed on payment of royalty and deed rent as per so and so. The lease was granted with a renewal clause giving option to the lessee to apply for renewal within a specified time before expiry of the leases. The petitioner applied for renewal of her lease in terms of renewal clause contained in the lease deed. Her application was rejected by referring to the amended provisions of West Bengal Minor Mineral Rules 2002, which was introduced in the year 2011 during the continuance of the leases of the petitioner. The amendments were given effect from 5th December 2011. The said amendment introduced a total change in the procedure for grant of mining lease in respect of the riverbed. The virus of the amendment of Rule 5 to 16 of the 2002 rules was challenged before division bench. By a judgment dated 4 July 2014, the division bench of this court was pleased to hold that the impugned decision taken by the concerned authority in refusing to grant the renewal of lease in favor of the petitioner is illegal and liable to be set aside. The concerned authority was directed to consider the petitioner's application for renewal in the light of provisions contained in Rule 12 of the Minor Mineral Rules 2002 and take its ultimate decision in regard without applying the provisions of amended rules which have already declared ultra vires. As this court is bound by the decision division bench dated 2nd December 2011, passed in by the ADM, Burdwan is set aside and quas ADM Burdwan is directed to consider the disposal of petitioner applicant renewal of mining lease in accordance with Rule 12 of the West Bengal Minor Mineral Rule within a period of 60 days. It is made clear petitioner also required to pay royalty. So, my lord, 2002 rules, no, my lord, defense taken by the state that in view of the Rule 16, my lord, Rule 61, my lord, of the 2016 amendment, this application has lived its life. It has lost its force. My lord, Section 11 of CPC. My lord, explanation 4, a defense which ought to have been taken at the relevant point of time. 2016 rules had come. If this defense was not taken, now constructive res judicata, they can't take it. Now the ADM, my lord, he takes recourse to Rule 61 and dismisses and rejects my application. One, that he does not act, my lord, strictly in terms of the order passed by this honorable court. His brief was limited to consider in terms of Rule 12 of 2002 rules.
Specific direction of the court. I do not know why so much of submission is necessary in this matter.
Agreed.
The direction of the court is has not been complied with.
My lord.
It is very clear from the order itself, isn't it?
My lord.
Let us see what the state has to say.
My lord.
You have already been favored with an order earlier.
My lord.
That was not complied.
But since a decision has come, my lord, a fresh cause of action, I am to come before my lord.
No, that's true. That's true.
I can't go in contempt.
I do not know whether the state has much to say. Yes. This is
On West Bengal minor middle rules 2002 minor, rule 36 provides for the appeal.
Have you challenged this order?
Which order, madam? Because of my-
The earlier order, yes, Justice Chaudhary's order.
We directed the authority to consider them. Accordingly, the order is hard to pass the order. This order has been challenged before this honorable court, but it's an available order under Rule 36. Minor middle concerns of 2002. Rule 36.
The order is in violation of the earlier order of the court.
Official of appeal, he may prefer the appeal before the appellate council. 2002, not 2022, the next. Rule 36.
Yes, this is an.
Was asked by the district authority, the appeal should lie before the state level.
May I address this? Lord, kindly Lord, permit me, Lord, to place Rule 36. Lord, any person aggrieved by an order made by the district authority or any officer duly authorized by in exercise of powers conferred upon him by these rules. Now, my lord, I say that the decision, my lord, under challenge is not solely in exercise of the power conferred. It is in terms of direction passed by the court.
The
And
primary-
this honorable, I'm sorry, my lord, subject to being corrected. And this honorable court only reminded that while carrying out the direction of this honorable court, he is to act in accordance with Rule 12. So he was then not exclusively exercising a power conferred to him under the statute. Lord, he was carrying out an order passed by the court and Lord, on the terms as set forth by the court in its order, that you must consider Rule 12. The consideration must be in terms of Rule 12. Lord, I say that, Lord, once he digresses from the direction, a fresh cause of action, Lord, arises. I am to come and only remind to this honorable court that this honorable court in coordinate bench has passed an order which has been considered in a way so as to circumvent it.
Well, the court has only given a guideline towards disposal, towards consideration.
Yes.
But the primary statute is 2002 rules.
But my lord, kindly my lord considers that my lord.
The order has not been, it has of course been passed in pursuant to the direction of the court in terms of, I mean, what is the guiding factor of the order is the 2002 rules.
Yes.
So why don't you approach the appropriate authority?
My lord, at the same
I
time.
grant you the.
But at the same time, my lord, at the same time, my lord would also consider, my lord, my application is, my lord, kept pending, my lord, for 8 long years. Lord, the question is one of livelihood. The question is one of livelihood. My lord, may kindly, my lord, remember that under such circumstances, this honorable court, my lord, has held, and also the honorable Supreme Court, my lord, has held
There is no penalty. It
Because
was
the
already
application was
expired.
disposed of in 2012,
Clear.
it was cancelled. Why, how this 8 years was kept
Submission
pending?
is not come.
His application for renewal was
No, no,
rejected
there,
in 2012.
after that, you approached this court twice, so it was
Milord,
going on.
Milord, kindly cease.
But the authority has not really delayed.
No, no, Milord, kindly cease, Milord, the delay, how this is being caused. Every time, Milord, this court is reminding the authorities to act in a particular way. Milord, they decide it in their own way and say that I have not delayed the things. Milord, it is in, Milord, a catch-22 situation where I am to come before this honorable court relegated to the authority disposes it in a way which this court has not desired, and thereby compelling me to come before this honorable court, and then a plea is taken that an alternative remedy is available, thereby relegating me again to the authorities, who would take again the same decision. 85 Supreme Court, my lord, human psychology is that to uphold its own decision. So, my lord, an appeal from Caesar to Caesar's wife, that was Sham and Sham company.
No, no, this is not.
No, they are justifying the delay. They are justifying the delay. They are just. Mr. Dasgupta, it's difficult.
I'm not Dasgupta.
Bandyopadhyay, sorry. The first name always comes with the surname. I'm so sorry. Now, my lord, I am only explaining, my lord, how the delay, my lord, has occurred. I have made the application in time. Now, this application has been held to be wrongly decided by this court. And when, my lord, an order is passed directing them to pass an order in accordance with the law and more particularly Rule 12, then, my lord, they say that an appeal, my lord, they decide it in accordance with 2016 rules. And when I challenge it, they say that an appeal
The
lies.
order is appealable under Rule 36. We cannot ignore this, isn't it?
My lord, my submission, my lord, to that, my lord, is, my lord, kindly considers, my lord, subject to my lord's kind pleasure, my lord, that when the authority was, my lord, considering, my lord, the order passed by this court, my lord, it was acting in terms of an order passed by this honorable court and not exclusively an exercise of powers conferred under the statute. This, my lord, this duty, my lord, which he was, my lord, carrying out was an onerous duty of compliance of an order passed by this honorable court. And he was to act in terms of Rule 12. Why? Because this honorable court desired him to act in terms of Rule 12. Lord, what happens, Lord? Lord, kindly not seize this.
It is a guideline to decide the matter. We cannot ignore the provision of appeal.
Lord, kindly not seize this. Lord, my lord has done.
Direct authority not to ignore the limitation part and decide it on merits.
Lord, only one thing, Lord. Lord, kindly seize this. Lord, had it not been this authority, and my lord, may have arrived at a coordinate bench, may have arrived at a conclusion that this authority, time and again being directed, is not acting in pursuance of this order. Lord, this honorable court could have directed another authority, whose order in terms of Rule 36 may not have been appealable. Lord, in that event also, Lord, I would have come before this honorable court. Why?
That's hypothetical.
Lord, what I am saying is, it is, Lord, an authority being vested with the power to act in terms of a direction passed by this honorable court. Lord, it is not an order in terms of.
Primarily, the power emanates from the rules itself.
Lord, the first round of litigation, Lord, I would have understood in the first round of litigation.
Really sorry, I think I have to relegate it.
Lord,
the limitation period will be condoned.
Lord, in an identical.
The authority to decide.
Lord, in an identical order in the first round, which I showed to my lord, page 92. Lord, in my case, Lord, they have not taken, my lord, the operation of the appeal, my lord, to be a ground of non-maintainability of the writ petition.
They have not taken the ground, it was not considered.
No, it is not. I am saying, my lord, can they now, my lord, in the second round of litigation, take up, my lord, in an identical order, my lord, this point of limitation, my lord, appeal being operative. Lord, this is not my lord.
Well, see, that order was moved. From the record, it appears it was moved ex parte. Nobody was present on behalf of the state respondent.
The respondents were not
Only the
present.
writ petitioner was present. Possibly it came as an old matter before the coordinate bench.
The respondents were not present. No submission.
So the
and my lord, kindly sees,
they were not represented at all.
My lord, now kindly sees, my lord, now the 2002 rules having been repealed, whether, my lord, the authority still is vested with the power, my lord, to decide the appeal.
That is as per court's order.
If the order has been passed.
No, my lord, an order.
Direction of the rule.
Just a second, sir, please. My lord, kindly sees, my consideration was a right which has accrued in my favor was to be decided in terms of a particular rule. Now it has been decided, but the rule stood repealed. If that be the case, the appellate authority conferred with the powers in terms of these rules, he is no more vested with the powers. It is now, my lord is, my lord is.
For the appellate authority, if the same order again comes, please come back after that.
Lord, my lord, my learned friend is now, my lord, now, my lord, my learned friend is, my lord, invoking my lord's powers to invest the authority with the power to decide the appeal. It would be a court conferred power, which otherwise, my lord, has been repealed. It is not that, my lord, I have a statutory appeal.
The original decision is under the 2002 Act, 2002 rules. So while preferring an appeal, you cannot say that since the rules are not there, appeal cannot be preferred. The original application, you are relying upon 2002 rules. And when it comes to an appeal, you cannot say that 2002 rules are.
And if that rule has been repealed, how could you claim benefit on the basis of that rule?
That is, I am claiming
that is on
that is an
application was filed.
When one point is, on the one hand, he is submitting that since the 2000 rule has been repealed, appeal cannot proceed. On the other hand, he is claiming benefit on 2002 rules.
May my lord come back, my lord, on, but kindly, my lord, sees this. My lord, my right, my lord, is directed to be considered in terms of Rule 12, in terms of an order passed by this court.
You have said this earlier.
Yes, but, my lord, the right of statutory appeal is non-existent today in view of the repealment of the statute. So I don't have
How it can
statutory.
One hand he is saying the rule 2002, another I was saying that it is repealed.
The repealment of
That cannot
2002, the repealment of 2002 rules, not, it takes away my statutory right.
For the reason your application will be considered under the 2002 rule. For the same reason, the appeal will be also considered under the 2002.
Then my lord will
Because
have
the
to.
entire thing is prior to that.
Then my lord will have to invest.
We cannot blow hot and cold in the same breath.
Yes.
It cannot be said that at the first instance it can be considered in the before the higher forum. It cannot be. When it is considered by the by the forum in the first instance under the 2002 rules, the appellate forum will also consider under the 2002.
My lord, only one submission I make. My lord, today
To continue further, I have to give you another date. Otherwise, I'll relegate it.
Kindly, my lord, another day. My lord, only one sentence, my lord, only one sentence. My lord, I know I am detaining your lordships, but only one sentence. My lord, when I came before this honorable court, my lord, I put this question to myself, whether Rule 36, the statutory appeal was available to me. My lord, the answer to that would be no, because until and unless today, in terms of my lord's order, the appellate authority is conferred with the power to entertain my appeal, would not have entertained my appeal at all. So I did no wrong by coming before my lord. My statutory right to statutory appeal was non-existent because the rules have been repealed. And to the limited extent of my application being considered in terms of Rule 12, by dint of the coordinate bench's order, the Rule 12, the 2002 rules were alive. Rest of it is all repealed. I could not have gone to the authority.
Then he has no relief at all in this.
May I file my affidavit of silence? I'm sorry to have detained your lordship.
Heard learned counsels for the affidavit of service. Heard learned counsels for the parties. Paragraph with the matter appear under the same heading on 18th April.
As your lordship.
May I mention one thing, my lord, in item number 672, and my name may be recorded, my lord.
You are appearing for?
For the private respondent, my lord.
No, it was recorded that nobody was appearing with the private despite service.
672, my lord.
It's already recorded. Despite service, nobody.
Order, my lord, I have no objection with an order, my lord. Only my name may be recorded, my
lord. Further hearing on this.
Only my name.
672 appeal. Where are the others? The petitioner, I cannot record your name like this. Who are the others? The petitioners and the state respondents?
Kindly fix it at 2. I am doing the petitioner and the.
You are appearing for all the private respondents?
Yes, all private respondents.
No grounds of those.
কেটে দিন ওই টাইমটা ওনার নামটা প্রাইভেট রেস্টুরেন্টের প্ল্যানটা কেটে দিন উনি অ্যাপিয়ার করছেন
Lord, I beg to appear on behalf of the Lord petitioners. Lord, it is an application for contempt. Lord, your lordship, while Lord dismissing an appeal under order 41.
Have you received the money?
Not yet.
Not yet.
No.
So will you serve and come back?
Yes, no. Your lordship can direct service, then we shall come.
Service direction. The applicant petitioners are directed to serve copy of the contempt application along with annexure thereto upon the alleged contemners and file affidavit of service on the adjourned date. এক মাস তো লাগবে at least service. April. 15th April.
My lord.
Let the matter appear under the same heading on 15th April 2024.
Grateful.
The alleged contemptor by name.
Yes.
This is my application, my lord. This is my application, my lord. We've concluded the submissions. This is for my learned friend to reply, my lord. There were several adjournments taken. I had objected to that on the last day, but she was given a last opportunity. There was only one order. This was not a part of my original arguments, my lord. My learned friend had taken one objection at the initial stage that the only judgment that we'd relied upon had possibly been watered down by a special bench of this court, my lord. I'm handing up a copy of the special bench, my lord, which he's referred to. It's not. The judgment has been relied upon. I don't want to make any submissions apropos this. I'll just hand up the copy, my lord. It's not been watered down. They've relied upon it. It's still good law. These are my submissions.
Will you refer to the relevant paragraphs?
Yes, madam, of course.
Because it's quite a longish judgment.
Yes, yes, madam. It's just one line, madam. সার্চ করো এরকম করে শুনানি করতে Lordship will kindly take up, my lord, page number 6. His Lordship, my lord, found page number 6, my lord, the last paragraph. It starts with the issues in.
The issues in Agarwal and Company.
Agarwal and Company, my lord, was the judgment that we relied upon. The contention that came from my learned senior friend was that possibly does not hold the good law anymore. Agarwal and Company and Ultratech Cement Limited was somewhat similar. In Agarwal and Company, there was short delivery of a substantial number of bags of iodized salt that had been loaded in Chirai at the destination station in Behrampur in this state. It transpired that the consignment was not weighed at the loading station and the railway receipts were issued as per the consignor's declaration of weight with the observation that the goods would be weighed en route to the destination station. The goods were weighed at some in-between place without reference to the consignor or consignee. And on the wagons being found to be loaded beyond the permissible limit, several bags were offloaded. The reason for the offloading of such bags was not immediately made known to the consignee at the destination station, and it was only after the delivery was obtained by the consignee that the railway slapped demands on the consignee for underpayment of freight, wherein it was disclosed that several bags had been offloaded en route to the destination station because of overloading of the relevant wagons. The consignee sought a reweightment upon receiving the demands. This, in effect, implied that the consignee disputed the claim of under declaration of weight at the loading station and underpayment of the freight due on the consignment. A petition under Article 226 of the Constitution was immediately carried by the consignee to this court against the demands raised and the arbitrary unloading of several bags and the sale thereof without notice to the consignee. The petition succeeded, and in the appeal before the division bench, the same bench which passed the present order of reference held, upon reading several provisions of the 1989 Act and the said manual as follows in paragraph 12 and 17 of the report. My lord, I'm not taking your lordship through the copy. That copy has already been handed over, my lord, on the previous day. Lordship kindly turns over to the next page, my lord. On the first paragraph, this is page 8, the quotation ends. The only reason I'm showing this judgment, my lord, is to show that Agarwal and company has not been watered down. That is still good law. That is the only reason. There's no other reason why I'm placing reliance upon this judgment.
That's all.
That is it.
Before I controvert, this thing, this in opposition. The lordship has got this.
Yes, yes.
Let's
Page 2.
Page 2. Paragraph 4. 4A. I have 4 lines. You have to kind of find. Take was booked as SMA, namely sender weight accepted consignment, and hence, as per extract rule, the rate was included and under the 9/11/2006. And the rate was finally released on 11/11/2006. Women's ship was sent to the border station instead of Ranaghat. The women's ship then sent to Naihati and thereafter on 12/4/2007 at Ranaghat received by the state. As immediately they have received the consignment, it was delivered properly, but there
Yes, yes.
Only point. They are well. The lordship kindly come to paragraph 6.
Yes.
I say that there is no such provision in the Railway Act to inform the consignor or consignee NOC to be present at the time of
Page 4. You're reading in page 4.
Page 4, paragraph 6.
Paragraph 6 is in page 3.
6.
Page
Yes.
Page 4. Page 4.
Page 3 is paragraph 6.
The lordship is looking at the affidavit in opposition, my lord. Paragraph 6 would be on page 4. The affidavit in opposition filed by the respondent. My lord. The copy that has been made over to us, at least, that is.
Starts with reference to the statements made in paragraphs 7, 8, 9. This is page 3.
Possibly different.
What is the extra page that has been incorporated here?
I got one on page 4.
Their affidavit in opposition, I think, was missing. They filed another copy before this court,
Yes.
possibly because of that.
Lost and I think
There's only one copy for the court.
I can hand up my copy for your lordship's convenience if it
No,
commences.
it's the same here, but then how that extra page has come, I don't really understand. Anyway, the contents are the same. No difference.
I say that there is no such provision in the Indian Railway Act to inform the consignor consignee endorsement present at the time of en route payment book under SM. Hence, the said rake of 35 box was paid and the payment result was received at the Ranaghat by post as specifically stated in paragraph 4B of the instant affidavit. Therefore, which is naturally due to what the question permit nothing to do. I further say that Respondent 6 would say superintendent is not empowered to take decision for waiver of any other charges. So he has nothing to do regarding the reply of the letter issued by the petitioner on 18/4/2006. I further say that the concerned payment sheet was not received by the petitioner on 2006. The said consignment was allowed to release from the said station and no objection was raised by the railway at the time. There was no objection raised by the railway authorities also.
That is for a different reason altogether. They did not receive the payment sheet. That's why they were not aware of it.
They have not received, but as per our record, it has been received by the consignment. That is, I'm showing you. Notice was served, admittedly. Notice was served from our part.
Upon the
petition on 9/5/2007. Because page we are telling us that is explained as per existing rules and as provided under section 80. Further said that the rate of 35 wagons were paid and computer is paid which was duly certified by the competent authority. Therefore, the overloading of 18/5/4 as shown after payment is absolutely correct and the petitioner is liable to pay the penalty. Where, madam, this issue comes. The punitive charges we have.
Where is the railway circular? Railway circular dealing with these punitive charges and en route weighing.
আমরা কপিও দিয়েছিলাম To be submitted a copy. I'm carrying an extra copy, Malad.
What is it?
This is the copy of the rules, Malad, of the railways. In fact, the judgment, Malad, Agarwal and company that we had cited, it takes into account all of those clauses of the.
Huh?
Yes, please come to rule 1424.
Before that, take their credibility in reply, where they have said that they have not copy of the purported rules and the trade rates for clause 170 to clause they which there is number 44. As referred, said affidavit and relied upon the respondent authority had next as is written there of the petition of at case 3.
Please give me a minute.
Paragraph 6. Case 3 of their reply.
Now, where is the reply?
Petitioner is supposed to get from our side.
জয়ন্ত দিদিকে রাখুন তো দিদি এফিডেভিট অফ রিপ্লাইটা রাখুন অপোজিশনটা পেয়েছি এফিডেভিট ইন রিপ্লাই সার্ভিস খুলে দেবেন Yes, affidavit in reply.
At page 3.
Page 3.
In paragraph 6.
Yes.
No copy of the purported rules and page for clause 172 clause 228 number 7 as referred in subparagraph relied upon the respondent authority had been annexed said as a taken care of the petitioner not in position to controvert the same.
Yes,
they could not controvert because of he could not supply or whatever they have, but we didn't ask for that. Now they are saying this, but it was never asked.
You have referred to the rules in your affidavit in
Yes.
opposition.
Yes.
So if you refer to a rule, you have to annex it with the affidavit.
I know, but I could not transfer this. But if you also show there, I can.
Yes, why don't you come back with the relevant rules and
Just a minute.
lien has become lion in the affidavit. Paragraph 4C. Penultimate line. Have been kept as lion at Ranaghat. It's lien there in your copy.
4C of the opposition, my lord.
4C of the opposition. Belongs to the same party, have been kept as.
No, my lord, in my copy it's EN, my lord.
Here it's lion.
Belongs to the same party, have been kept as lien at Ranaghat on and from.
Lien has
third.
become lion in this copy. LION.
Considering that it's their opposition, I will not defend it.
Yes, do you have these circulars with you? Freight rates clause 170 to clause 220. These are all mentioned in the opposition.
Yes, they were, my lord, but I am willing to let go of that also. I am saying that I am conceding to whatever rules they've relied upon. I don't think that would otherwise be relevant because as per the my lordship only is required, my lord, in my understanding, only required to look at, my lord, the judgment of Union of India, my lord, versus MS Agarwal and Company that in fact quotes verbatim the rules that the railway has relied upon. According to that, my lord, the division bench, the honorable division bench relies upon the fact that at any time, if there is a reweighing that happens and there is a there has to be upon notice, I would have to be given an opportunity. That copy of the judgment I've relied, my lord, but may I just read that line, my lord? It might
Let me
assist.
find out the judgment.
Sorry, I mean, actually sentence. What are the words? It'll be a photocopy of a certified copy, my lord, because we had not been able to. This was 2007. We had not been able to obtain any copy from either the server nor a reported judgment.
It's MAT 409.
This is MAT 409 of 2007, my lord. Lordship looks at page number 22. This was the only portion that I was relying upon with respect to the law, my lord. Page 22, my lord, last paragraph. Prior to this, my lord, all the rules have been verbatim referred to. 22, my lord, the last paragraph. In order to take punitive charge for overloading a wagon, the concerned parties must be given intimation of the overloading. And once the goods have been booked after due weightment, such punitive charge cannot be levied unless the goods are reweighed at the presence of the representatives of the parties concerned. As provided in para 1451 of the IRCM rules, my lord, these have been quoted. Receipt should not be granted till the goods are correctly examined and weighed.
Just refer to the rules. I have just asked learned counsel about
Those
this.
are there, my lord. Those are there with your lordship's records, my lord. We've handed over an extra copy. Those are, if your lordship looks at, my lord, page number 13 of the judgment onwards. Actually, page number prior to that also, because the sections of the Railways Act are there. But apropos the rules, lordship kindly looks at page 13 of the judgment.
Yes.
The regulations. So all the rules have been
Yeah, they are set.
disclosed.
We are trying to find out the notice which we have served upon them.
Prior to reweighment.
Yes.
Prior to reweighment, you say you have issued notice.
Yeah.
Not disclosed in the affidavit in opposition. There is, doesn't have a single annexure.
Affidavit.
It's not on record. You can't rely upon it today.
The old record, my lord. So I have to find out from here only. And my officer is.
No, not old record. It's good. No, the affidavit in opposition was given on the 3rd of August 2007, not old record at all. The pleadings were completed several years back.
2006. I am showing the letter.
Let that come on record by way of an affidavit.
Yeah, I'll
Because
be opposing to that. Well, I'll be opposing to any supplementary coming at this stage. This 2007 application. Pleadings were completed within a few months.
Please show me.
She finds that
Because the entire writ petition is based on this, where the notice was served.
And they have
And
been granted that opportunity, my lord, in 2007. They've chosen to file an affidavit in opposition. So many years have gone by. On the hearing of this writ application, my lord, a year has passed by.
This is a letter for payment of punitive charges. Where is the notice prior to reweighment?
That is.
If there is no such notice, the writ petition will be allowed and the entire case goes.
14/4/2007 is their first communication to me.
So let me reserve the matter for order.
Yes, my lordship reserves it.
The entire case rests on that notice.
or 2 minutes.
Let him come back next week. Next week, I'll conclude the hearing. I'll reserve
Lordship
the.
closes the arguments in the next.
Please come back next week. I only want to see that notice.
Only that is.
Whether notice was served prior to repayment and the petitioners were granted opportunity of hearing. That is all that is required in this matter.
Definitely not speak for that. That they should be.
Yes, but that notice is not on record till date.
Actually, with the deepest of respect, my lord, even if today they wouldn't
Come
have
back
any
next week. You waited for a long time.
difficulty,
Another
I'll indicate. I don't have a difficulty coming back. The only two prongs, my lord. First is today, even if there's a notice, he would not be in law, otherwise be able to ascertain whether that was delivered to me or not, because there'd be no track record.
premature submissions. Let the notice come.
Come back.
Learned counsel himself also has doubts as to whether the notice was there. So let it come.
Okay.
Why waste your words? Yes. Heard learned counsel for the respondents. Paragraph, let the matter appear under the next day, no further adjournment. I'll conclude your.
I have brought the file. But you can. Lordship's query, your lordship kindly.
20th March.
Only thing you query, your lordship only kindly keep it on record that your lordship is asking for that is.
I don't have a difficulty, your lordship.
That line add করুন her learned counsel for the पूरी तारीख her learned counsel for the respondents করলেন তো ওখানে করুন learned counsel for the respondents submits that notice was served upon the petitioners prior to conducting en route repayment of the goods. Learned counsel seeks to produce the said notice on the agenda date. Paragraph, let the matter appear under the same heading on 20th. 20th March into en route, en route আলাদা আলাদা শব্দ en route repayment.
I'm deeply obliged.
Next.
Your Lordship, I appear on behalf of the state, Your Lordship. I was supposed to file a report. Your Lordship, the instructions are there. The report is a very short accommodation. Yes. A very short accommodation, Your Lordship. Unconditional apology for the delay.
Short matter. Why don't you come with your report? Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same heading on 12th April.
It would be supplied to me.
I will serve.
Advance copy.
Yes, I will
Advance
serve
copy,
on a
please.
plan.
Yes. Next.
The applicant, my recalling application.
Well, I am appearing, my lord.
Lordship, this is my recalling application, which your lordship had heard on the last two occasions. Lordship, due to paucity of time, the order could not be passed. Lordship, of an order dated 16th of October 2023. Lordship, on four grounds. A, your lordship, suppression of fact. The writ petitioner has suppressed the fact that the section 9 was filed. B, your lordship, there is no urgency whatsoever. The vehicle was sold way back in 2022, August 2022, and the respondent and the writ petitioner had come up and filed a complaint on 22nd of September 2023.
You are absolutely on merit.
Lordship, I am only against.
Can this court sit in appeal?
Your lordship may kindly hear me once. Your lordship may kindly take up the order dated
The order, let me go through the order.
16th of October 2023 at page 16.
Yes, what is your
Your Lordship, I am
recall?
Your Lordship, I am aggrieved by
Who
Your
is the
Lordship.
petitioner in this matter?
Lordship,
You
my
are the
learned friend is for the writ petitioner.
Yes.
Lordship, kindly takes page 18 of my application.
Order on?
I think so.
No, Your Lordship.
There is no, they haven't filed any other affidavit in opposition in this way. But the order you are saying.
No, it is his application for recalling.
Recalling, Your Lordship.
Yes, affidavit in opposition was filed, but who is the fifth respondent?
Lordship, I am. Lordship, the applicant before. Your Lordship, I am appearing for Tata Motors.
Tata Motors is the fifth respondent, my lord.
But as well as super high recollect this was of the few that he considers an affidavit in opposition to the restriction. I think.
No, Your Lordship, the order does not reflect.
Oh, you, so far, why this order? Have you seen this order? Last order?
Where is the affidavit? An affidavit in opposition was filed in this matter.
No, Your Lordship.
You haven't filed. So why this? But I don't know. That's
Your Lordship, it ought to have been the affidavit.
Affidavit in opposition filed by the fifth respondent. This is your
Lordship.
affidavit in opposition? Against?
Your Lordship, may I just have a.
Yes, give me a minute. Oh, to the can filed by the fifth respondent.
Grateful. Your Lordship, this opposition came in and I have not used a
This
reply.
opposition is filed by the petitioner. By
Lordship.
you. Lordship.
Your Lordship, that opposition is from the petitioner. I have not used a reply to the can application.
You don't know how to use a
No, Your
reply.
Lordship. I'm on a very limited ground, Your Lordship.
that I have already filed.
It has been recorded wrongly
Wrongly.
and the necessary corrections. Yes.
Lordship. Lordship, I am on a limited ground. Lordship, this order at page 18, if Your Lordship sees, I was not given any notice before moving this matter. This matter was,
It's at the admission stage.
Lordship, at the admission stage. Lordship, this order was ex parte. No notice given to me. This was moved. Lordship, Lordship, the urgency was there was no urgency, and this matter was mentioned before and bench, which was taking up the urgent determination without giving me a notice. Lordship, what prejudice that I have suffered is even before this writ petition was filed, 1 year before this writ petition was filed, in fact, Lordship, I had already sold the vehicle. And Your Lordship, this is after 1 year. And more than that, Your Lordship, the writ petitioner had suppressed the fact that they themselves had filed a Section 9 application before the district court at Birbhum, which I have annexed in my CAN application, which the writ petition is completely silent about. And which was,
An application with regard to what?
Your Lordship, with respect to the same vehicle. In January 20. Lordship, if my learned friend would allow me, Your Lordship.
That's a different issue altogether.
No, Your Lordship, this suppression of the fact that they had gone to the arbitration court the Section 9 was ultimately dismissed, and then as an afterthought they come up before this court by way of a writ petition asking for an order without giving me notice. Otherwise, Your Lordship, I would have apprised that the vehicle has already been sold 1 year back, and this order, which Your Lordship sees at page 18, which records in the meantime the finance company, that is Tata Motors, is directed not to transfer the registered owner in favor of any third party for a period of 1 month, would not lie. Lordship, I am being injuncted for an act which has been already done in the past. Your Lordship, 1 year before. If Your Lordship,
The Section 9 order.
Lordship, Section 9 application, Your Lordship will find.
I've seen.
Your Lordship, the order is not there. The Section 9 application is at page 26, and Your Lordship will find the praise at page 33. This was filed in January 2021, and the writ petition is completely silent about this. So one of the grounds is suppression of fact, Your Lordship. This Section 9 application.
I propose to deal with the writ petition itself.
Very well, Your Lordship, but.
If there is suppression, nothing further remains.
Lordship, because there ought to be some urgency by mayor giving a letter on 22nd of September 2023 that we are selling the vehicle.
Section 9 was dismissed.
Yes, Your Lordship.
Do you have a copy of the
Lordship, I do not have a copy of the order, but I have stated it was dismissed on 29th of September 2021. Way back 1 year before.
I fine. Section 9 was on the same ground.
Because there was an arbitration clause, your lordship. My learned friend had tried his luck before the arbitration court, did not get an order, and has, in order to circumvent that order, has come up before this honorable court by way of a writ petition. And your lordship, if a notice was served upon me, at least I would have the opportunity to apprise this bench that, your lordship, the vehicle has already been sold. I would not have suffered this injunction. So I request my learned friend to show any notice on me showing that this matter is being mentioned before the bench taking up the urgent determination. There was no notice absolutely. The bench taking up the urgent determination took up the matter, and on the basis of the submissions made, this order was passed. The vehicle was taken possession on 9th of December 2020. Almost 3 years. Then they file a Section 9 application.
Transferred?
Lordship?
When was it transferred?
Lordship, the transfer was effected on 31st of August 2022, after 2 years.
And the Section 9 filed on the arbitration?
January 2021. Your lordship, December 2020, I take possession. They go and file in Section 9 in January 2021. Do not get any order. That gets dismissed. They sit on it. Your lordship, since the Section 9 is dismissed, there is no injunction. The company proceeds to sell with it. It's sold on 31st of August 2022.
After dismissal?
Yes, your lordship. There was no embargo on me.
No, there was not.
So if the writ petition would have come with clean hands, your lordship. And even after.
Let us hear the petition. Yes, Mr. Mukherjee.
That's not Section 9. But your lordship, aware of this petition, arbitration clause even there. What are the players made here? What are the players made here? And the I have no response against this private response. Because the process, but I have challenged here the process of transferring.
Have you stated the arbitration in your writ petition?
That I have whether enumerated pedagogical facts and central rules that has been by the state respondent while transferring. Point one is this.
That comes later.
So your lordship kindly appreciate one. Died. Now after his death, private the respondent number 5 took over the position. Now they have the right to sold him with. That is there in subsection 5. Now the authority has to say in noticing that event. It is admitted fact that they took over the position. I am not on that. They took over the position.
After the vehicle was taken over,
yes,
you approached the arbitrator.
No, not arbitrator.
Yes.
No, no. Section 9, the court has to pass the interim order.
Yes.
No,
It is an arbitration. Yes. I coined the wrong word.
I feel there is not that on merit. So far afterwards, I have collected.
Please see your prayers in the arbitration, Section 9.
So that in there, these informations came later to me that that is the prayer which has been not failed. This was dismissed for default. Yes, I will produce the order by which this dismissed for default is there. Subsequently, I was informed that yes, application was made there, but that was dismissed not on merit.
Maybe that is irrelevant.
That is not there.
Irrelevant. So that is sufficient suppression.
But I should admit, but the thing is this, the kindly appreciate one thing, but the process which has been, this is the special act.
Maybe you cannot suppress material facts.
That's the official. Now, one, assume if something has been done, close to the statute, which is a special act. Assuming that has not been agitated, but
you are on merits. You are on merits of the petition. The court will not enter into merits at all if there is a suppression of material facts. But there are several Supreme Court judgments, and you are aware.
Then, I will produce judgment that whether this is a material fact to be suppressed. In the context of this writ petition,
Is very much
Whether-
good.
but that was dismissed for default. I have got
Mr. Mukherjee, so far as I have learned, gathered from this, the vehicle was taken possession of, then section 9 was filed. Section 9 was dismissed for whatever reason. So there was no embargo, the vehicle was sold. After that, you come before this court.
But there is no embargo.
Where is the embargo?
Embargo.
Embargo on embargo on the on behalf of the private.
No embargo on the private respondent.
To sell the vehicle.
Yes, where is
No,
the
but
embargo?
there is no provision. How they say they can sell the vehicle?
Rightly or wrongly, they have
No,
sold
this
and you have
the law whether permits them to sell the vehicle, whether they have any order. to sell the vehicle.
preliminarily suppression of material facts.
But
I am
that-
not
but
going
you
to
know,
merits at all.
Your Lordship, on this, that they, as because there is section 9 dismissed, whether on the grounds on the merit or whether it is on the grounds of default, they have got the right to sell the
I am
vehicle.
not on merits at all, Mr. Mukherjee. I am only on suppression of material facts. Mr. Devra, anything to add?
No, no, my lord, the lordship correctly just says this. But purely suppression of material fact, my lord. It cannot be entertained, my lord. Lordship cannot be entertained.
The vehicle
This type of
was
petition.
dealt with in a section 9 application, you have just chosen just to remain silent about it in the writ petition, only to obtain an order from the court. It will be dismissed on this ground itself. I'm sorry.
Liberty may be given.
No liberty.
No question of liberty. Liberty. What liberty?
No liberty at all.
All my lord.
As you sow, so you reap. The WPA along with CAN করবে না? আছে, এটা আছে, ঠিক আছে। এখানে কোনো inadvertent error has crept into the order passed on February 9, 2024. In the first line of the order, inverted comma open করুন। Affidavit in opposition submitted on behalf of the respondent number 5, inverted comma close করুন, be read as affidavit in opposition submitted on behalf of the petitioner. এটাও inverted comma রাখুন। Affidavit. A paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on February 9, 2024. It is your affidavit, not theirs. Paragraph. Heard learned counsels for the parties.
কিছু কর মামলা হচ্ছে না মামলা করতে পারছি না তো আসতে যাচ্ছে এতগুলো মামলা আমার প্রায় নিচে सोच रहा हूँ मेरा ब्रीफ यहीं कर डेट्स
The
डेट्स जो भी मांगे ना
writ petitioner seeks a writ in the nature of mandamus, commanding the respondents to show cause as to why the impugned transfer of ownership of the vehicle bearing number WB 455212 should not be quashed, comma, recalled, comma, cancelled. Paragraph. The vehicle in question was registered in the name of the petitioner's husband, on the basis of a hire purchase agreement. Stop. The owner of the vehicle failed to pay the installments to the financer, being the fifth respondent here. You're the financer, fifth respondent herein, for which the vehicle was repossessed by the fifth respondent on 30th December.
Lordship, 9th December 2020.
On 9th December 2020. Stop. The owner expired on 25th May 2020. The arbitrary reference was made by the petitioner.
Lordship, the writ petitioner had approached the court for under section 9.
The petitioner received information that the fifth respondent sold the vehicle in favor of a third person, following which the petitioner made a written complaint before the registering authority on 22nd.
The registering authority that was given after what?
22nd September.
Lordship, 22nd September 2020.
That is page 7 of your writ petition.
Paragraph 7.
Page 7 of your writ petition.
Paragraph 7 है बोला चाहिए.
Page 7, yes, 22nd September 2023. You say you made a written complaint to the registering authority. 23, yes. September 2023. Alleging that the provision laid down under section 51 within bracket 5 of the Motor Vehicles Act 1988 was not complied with. Stop. By an order passed on 16th October 2023, this court admitted the writ petition for hearing subject to payment of admitted arrears are subject to the petitioner paying admitted arrears, payment arrears to which the financer is entitled, within 21 days from the date of order. Stop. The financer was directed to inform the petitioner about the current arrears on her application made in this regard. On payment of such arrear EMI by the petitioner, she was granted liberty to file appropriate application for return of the vehicle from the financer and to take steps for registering the vehicle in her name as the wife of the registered owner, since deceased. Stop. In the meantime, the financer was directed not to transfer the vehicle in favor of any third party for a period of 1 month. The financer, being the fifth respondent herein, has filed an application being Can 1 of 2023, wherein he has primarily alleged suppression of material facts by the petitioner. Paragraph. Learned counsel for the fifth respondent has submitted that the financer took possession of the vehicle on 9th December 2020 in terms of the loan cum hypothecation agreement dated 25th July 2018. Stop. The petitioner approached this court under section 9 of the arbitration and conciliation district judge. Approached the court of the learned district judge Birbhum, Birbhum at Shuri under section 9 of the Arbitration and Conciliation Act, 1996, which was registered as reference case number 07 of 2021. Praying for interim measures of protection in respect of the vehicle in question by way of detention, preservation or inspection, and injunction restraining the respondents from transferring the vehicle till disbursement of the insurance claim. Learned counsel submits that the said application was dismissed by an order passed on
29th of September 2021.
It was dismissed on 9th September.
29th September 2021. Lordship.
29th September 2021. When was the vehicle sold out?
Lordship, the vehicle was sold on 31st of August 2022.
The vehicle was sold out by the financer on 31st August 2022. Stop. Learned counsel further submits that being unsuccessful in the application under section 9 of the Act of 1956, 96, the petitioner has come up before this court with a similar prayer upon suppressing the earlier application filed under Section 9, which amounts to suppression of material facts, sufficient to dismiss the writ petition. Correct. It appears from the record that
May I have your lordship's kind leave?
that filing of the application under Section 9 of the 1996 Act and dismissal of the same was suppressed, were suppressed by the petitioner before this court in filing the writ application. It is trite law that a petitioner should come before a writ court with clean hands, and suppression of any fact material to the writ petition by the petitioner shall lead to dismissal of the writ petition without entering into merits thereof. Paragraph, since it is evident from the record that the petitioner is guilty of suppression of material facts before this court, this court is inclined to hold that the writ petition ought to be dismissed on the said ground alone without entering into the merits thereof. Paragraph, in view of the above, the writ petition being WPA such and such is dismissed. There shall, however, Can 1 of 2023, the connected application being Can 1 of 2023 is disposed of. There shall, however, no orders to cause, since no affidavit, urgency defendants.
Deep look, sir.
Next. Yes.
I am appearing, my lord. I am appearing for the respondent.
So I have to file in Section 9. But whether I subsequently I got this notice, I will not have.
You need to have instructions. You are mentioning on instructions. You are not personally liable for anything. But this is suppression by the petition. By the petition. Yes, you are the petitioner in this matter?
I am for the respondent.
Thirty is the 32. Yes.
Paragraph 5. As per the clear yes, that has to be answered by
The state, the respondent. Yes.
Whereas what is your is that the party is liable. Observe that it not cancel.
Mr. Mukherjee, take mic, please. Microphone can.
He's not able to hear.
Sorry, my lord. I interrupt. Sorry.
Well, this has already been heard by my lord. My lord, this was the Mr. Debra has to produce what I don't know whether one uh, uh, judgment or something that by which he tried to my lord, establish that in case of a commercial vehicle there is no provisions. You cannot purchase a vehicle before the offer letter is issued if it is a commercial one, or the replacement order is issued. But only one thing, on the last occasion I failed to place their rules. Rule, your lordship kindly take the West Bengal motor vehicles rules.
The West Bengal rules study into.
আচ্ছা আর একটা কপি আছে
West Bengal Motor Vehicles Safety Center.
Well, may I hand over my lord the copy?
Yes.
Your lordship kindly come to rule 123.
Form of application.
Yes. Now your lordship come to the forms appended to the rule. That's the part of the rule. Forms appended to the rule, your lordship will find form 1, that in respect of the stage carriage.
Form 1, yes.
Now your lordship kindly, these are the serial numbers, full name, the applicant's name, then so and so, so and so. Now your lordship straightway come, I skip over the straightway come and 10A. Now these forms says particulars of vehicles owned by the applicant or in his control for which permits is sought. So these, there is both sides. So I can produce a vehicle at the time of making of this application, so offer letters need not be required to issue. First, this is the rule. This is the forms appended to the rule, and your lordship is aware of this. Forms appended to the rule is the part of the rule. And that too, in respect of the commercial vehicle, because this is stage carriage.
Yes.
At 86. Last paragraph, whereas subsection 1C of section 86. My understanding, it's right that the vehicle, if the start, cancellation and suspension of permit. Section 86.
So there was no vehicle when the permit, the application was made.
No, this is not the case. Here the case is that the petitioner was the permit holder. Now he failed to made an application within the time frame
For renewal.
And the vehicle was seized by the financier bank, the Contai Cooperative Bank. He informed this, and he was of the view that he can get back because he filed a petition there. Still that is pending, that is appearing I have annexed. Now all these facts has been ventilated by way of my lord's order that a comprehensive representation to be made for considerations of this part. So that has been made. Thereafter, this decision has come. And my lord, I have also shown my lord the rule. They are my lord the rules, my lord the acts also. Let's say কত number এটা? Acts হচ্ছে renewal কোনটা? হ্যাঁ? হ্যাঁ? না acts এ বলো না। Only also can see.
The new vehicle was not ready when the application was made.
Yes, my lord. Now we will also going to see the renewal part. That is also important, my lord. Section 86 of the Act. That also, I mean, I have a good one that. Thank you. Section 86, duration and renewal.
Yes.
Now, you see, a permit other than a temporary permit issued under section 81. Under section 8.
It's cancellation and suspension.
No, section 81. Well, the renewal part. Section 81 of the Act. Well, general provisions is that the permit has to be renewed. A permit is valid for a period of 5 years. It has to be an application has to be made prior to the expiry of the permit within 1 month from the before the expiry of the permit. That is in general rules that has the section says. Now that is the section. Now subsection 3 you will also come to notwithstanding anything content, but this is non-obstante clause. But notwithstanding anything content in subsection 2, the regional transport authority or state transport authority, as the case may be, entertain an application for renewal of a permit after the last date specified in that subsection, if it is satisfied that the applicant was prevented by good and sufficient cause from making the application within the time specified. Now, that also, my lord, I have stated in my comprehensive representation. Now, we will also kindly come the power also, my lord, this is the power conferred under the Act, and also, my lord, according to the rule, West Bengal Motor Vehicles Rules frame, you will also kindly come to, my lord, Rule 151 of the West Bengal Motor Vehicles Rules.
Yes.
Application for renewal of permit or renewal of counter signatures, but these fees specified in Schedule A3. Now, Schedule A3, as your lordship will find, Schedule A3, clause 5 of Schedule A3. There is a reasons also.
Yes.
Beyond 90 days, but subject to specific approval of the regional transport or the state transport. The provisions is there. I am not saying that this is a mandatory one, but they ought to have considered the reasons for making the applications after the expiry of the permit, which has been given in section 81. The section 81 also that specified. I have stated in paragraphs.
They have not taken this ground that you have applied after expiry. Their grounds are different.
No, though that can be, but they are saying that as because the vehicles was not there, so 86 will apply. 86 subsection 1C. Now, 86 itself and a provision by which there are two types of one is the cancellation, other is suspension. Subject to mileage collection, the vehicle, if I intend to place, if I have intent to place the vehicle, and unless it is the section 86, unless subject to my understanding, 86.
It says you cease to own this.
That subject to mileage correction, you will also kindly see.
86 1C.
Yes, but I am
Is
on
to operate.
I am on this. Kindly come to my lord 86 1 1D. D. Now, my understanding, the word cancellation, if I obtain the permit by fraud or misrepresentation, other things, if a permit is there, only the vehicle is not there. If I intend to place another vehicle,
C is
it may be invalid permit, that the operation is suspended due to non-existence of the vehicle in that permit. The moment I asked, they could have considered that way, that whether what is prevented me from making the application for renewal, as well as why I was not placed the vehicle, because the reasons are there. I have given the reasons in my representations, and I have dealt with all these paragraphs in the writ petition. They could have considered, and they say, no, this cannot be. Because of this, one cannot wait.
Mr. Mukherjee, there's a full court reference. to
My
this.
time.
Please continue on the next day. Mr. Devra,
Yes, yes.
third learned counsel for the petitioners. Paragraph, let the matter appear under the same heading on 10th April.
10th April.
নেই তো কিছু 10th এপ্রিল বাইরে যাওয়ার কোনো ব্যাপার নেই তো
দেখ
ভালো।
deep love, my lord.